May I please watch?
Huh.
So I will be allowed to move an urgent motion either tomorrow or day after tomorrow.
What is it?
Also, this is with regard to also this is for compliance. Because there is a division bench order for holding a regular selection in terms of the 2003 rules. That is a order of 2023. That has not been complied. Now a general advertisement has been issued.
What is the urgency? 23 non-compliance. Okay, you get it
23
day after.
non-compliance lawsuit now
Okay, okay, get it day after. Motion day, get it.
Wednesday.
Wednesday.
May I please, Your Lordship? I want to withdraw writ petition, Lordship, day after tomorrow. Deeply
May
please.
please, Your Lordship. Let to mention for listing for motion, Lordship, day after tomorrow.
What is the urgency?
Lordship, earlier matter was listed before this honorable court, and your Lordship was pleased to direct that coordinate bench of this honorable court was considering joint committee. That judgment has already been delivered.
May it please, Your Lordship. Lordship, I beg to mention item number 50 with the Panchananda petition.
50?
50, Lordship.
Magad University, what happened?
Lordship, I have got some instruction, but that is not.
That was the instruction. Last date also you said you have the instructions. Now you will file the affidavit.
Yeah, but that is, I have gone through it. That is not sufficient, Lordship.
This
I
is
have,
not the way,
I have,
Mr.
Lordship. Not only Lordship, no, here, Lordship, the issue of giving associates.
Whatever, it is,
Yes,
bring
yes,
it on
yeah.
record, we will decide.
Yes, Lordship.
Huh? You have been taking time daily only on that. That doesn't look nice.
Lordship, as per the instruction, because I have received that part of it.
No, if they are not giving you, who is not giving you complete instruction? Tell us,
No.
we'll ask them to be here.
This time I will receive, Lordship.
Mr. A.R. Tabilda submits that an affidavit on behalf of the respondents represented by him, standing counsel, higher education. No?
Lordship.
An affidavit on behalf of the respondents represented by him would be filed on or before 17/7/2027 without fail. No further adjournment shall be granted for filing of the affidavit. Registry to list this matter again on 27/7/2026.
27/7, Lordship.
Lordship.
And your affidavit should come on record on 17th.
Lordship, after 20, Lordship, some time may required. Therefore, I am say 27. It's okay, Lordship, but
No. You filed the affidavit on
Yes,
by
yes.
24 for you.
24. Yes, I'll ensure. Lordship.
24, a registry to list this matter again on 31.
Lordship. Lordship.
May I please? Oblige.
Yes, Miss Devi, what is it?
He would like to mention item
Lordship,
oh,
item
but
30, Lordship.
30, but Lordship has passed out as a last.
Today, during the course.
Last chance, man.
yeah, I had-
Has passed last
Yes,
decision.
That is that Dorpan.
yes, Lordship.
Dorpan High Secondary School.
It has already been approved.
Lordship, today,
That's
by the,
nice.
during the course.
Mr. P.P. Dr. Leonard, Standing Counsel, Secondary Education
Witness
Department,
day.
submits that he would file an affidavit, the affidavit on behalf of the respondents represented by him is being filed today. The registry to list this matter again on
Witness day, my lord. The
25.
Lordship.
25
July,
July. No.
June.
June.
We'll have it on reopening. You
Yeah, yes.
14/7/2026.
Oblige, Lordship.
May I please, Your Lordship?
25 no ke?
When do you want? Urgency is there.
Tomorrow is.
Yes, my lord.
Okay.
Tomorrow is
Then
result is going to
25.
be declared.
Declared.
Huh?
That compartmental.
Complimentary exam will be
Okay.
witness day, my lord.
Okay, 24.
24. Highly obliged.
June launch.
24
Okay.
June.
May I please, Your Lordship?
How dare I? When Ms. Devi is appearing, give it a date inconsistent with her request. Yes,
Below, I am mentioning Lordship for a listing of a writ petition, Lordship.
all listing. All
Ma'am.
listing.
Oblige, Lordship.
May I please your lordship? Lordship, with the consent of the other side, I beg to mention item number 23, lordship. Lordship, conducting counsel P. Boiragi is not well, lordship. Kindly adjourn for the day, lordship. Item 23.
This is reset for your impleading.
Yes, lordship.
What is this? He is not keeping well.
Yes, lordship.
Lordship, in this matter, Lordship, I am for the writ petitioner, Lordship. In the writ petitioner, government have to file an affidavit, Lordship, higher education.
Today
Record
it's
already
why
issued.
we'll see, fix it after the vacations.
Immediately after vacation, Lordship. But
A
the
prayer is made on behalf of Ayatut Marivida. A prayer is made on behalf of Mr. P. Boiragi, Learned Counsel for the applicant for an adjournment in the matter on the ground that he is indisposed. So, in view of the above, registry to list this matter again, along with the connected writ petition on 15/7/2026.
Oblige, lordship.
Please, your lordship, with the consent of other side, item number 27, respondent number 8 has filed one affidavit. We seek some time for filing our reply. Item number 27, admission column.
Miss
Didas.
Leaders, learned counsel appearing for the petitioner submits that she be granted further 3 weeks' time to file a rejoinder to the affidavit filed by the respondents. Pray accepted, registry to list this matter again after 3 weeks on a date to be fixed by it.
My lord, it's regarding item number 63, my lord, supply. Now, with the
That's,
content of-
You were supposed to file an affidavit,
Yes, my lord.
undertaking.
My lord.
Yes.
That- My lord, with the consent of the other side, my lord, the matter may be taken up after vacation. My lord.
Why?
My lord, in the meantime, my lord,
Mr.
I have some personal difficulty
No, no,
today.
fine, we'll not take that. But is such undertakings mandated? Say tomorrow that man may have 101 problems.
My lord.
So that you bind him that whenever we give you, you will have to complete it within a period so and so.
My lord,
It's not
there's
a
a
nice-
finer difference between that warning and censure, my lord. Administrative, my
You,
lord,
if
that
there
is
is
why-
a misconduct,
my lord,
you proceed against him.
my lord, that is why, my lord.
Whether can you bind a government employee in this manner? That much is my
My
doubt.
lord.
A prayer is made by Mr. PJ Fukan, Learned Standing Counsel, Gauhati University, submits that. You will file an affidavit.
My lord, yes, my lord.
Submits that an affidavit would be filed in the matter on behalf of the respondents represented by him on or before. When?
My lord, third week of July, my lord.
On or before 15/7/2026. Registry to list this matter again on 22/7/2026.
Can it be 27, my lord? Sorry, 17, my lord.
17th, okay.
Minute.
Then it will be 24th, huh? 17th filing, 24th listed. Yes.
Most obliged.
Wait, please, your lordship. Lordship, make a prayer for requisition in item number 32. Lordship, we had filed an additional affidavit that we will bring on record. The matter is fixed for hearing at 2 p.m. Lordship. Deeply obliged.
Wait, please, your
Have you
lordship.
served the copy?
Lordship.
Yes, no, sir.
Lordship, I'm paying for listening a IA on 25th, my lord, because main case is fixed on 25th, my lord.
What is the IA for?
IA for recalling the order of this honorable court, my lord, because direction was given, my lord, to comply with the order of this honorable court, my lord, but it is not in our jurisdiction, my lord. It is under the BTC, my lord. Obliged.
May it please, your lordship. Lordship, I beg to mention for listing one motion matter on Wednesday.
What is the urgency?
Urgency.
Urgency, two things. Vacation is coming, so urgent. Or there is some other urgency.
Urgency is also there.
Birospati, Thursday.
Here, on Thursday, I will be out on.
Oh, the Budbar.
I'm deeply.
Ms. Sharma, sorry we had to go against you. We have dismissed the appeal. We have found the girl to be consistent in
Got it.
3 places. 1, before her 164 statement. 2, before PW10. PW10, the name was not said, but the description was given.
Got it.
PW10 deposed in the inquiry. You had not even put a suggestion that the description does not fit the petitioner, the appellant.
Otherwise, he had almost served his sentence.
Oh, whatever it is.
Lordship.
Some corrections are there. I'll upload it in the by evening. Till.
Obliged.
Number 4.
Ms. Wangla, where is Mr. Dotto?
Lordship is out of station. Lordship, may kindly.
See, I had dictated the order. My order is otherwise ready. The only problem that I find is, while I was going through the matter, first 2004, there was a penalty, right?
Yes.
That was then modified in 2016. made it effective from 2016.
Yes.
I can tell openly, I had now said that that is not commensurating. So I had converted it into 2 penalty withholding. But what I find is, in 2016, when you had imposed that penalty prospectively, he was already 69 years. Retirement age is 60.
Yes.
Now, after retirement, could you have imposed that penalty?
I need to.
There's nobody, there is not even a whisper anything. Can you get Mr. Gogoi?
My lord, my lord.
We'll take it up.
Kindly take it. to
Oh,
board.
I'll not pass any order without hearing Mr. Dotto. But I just want to know whether there is a provision in the university that permits the delinquent to be continued after retirement for the purpose of punishment. That much only. If that is there, I'll declare the result today only.
My lord.
Obliged.
When is Mr. Dotto coming back?
Tomorrow he'll be here.
Okay, okay. We just have a thing from, then we'll hear Mr. Dotto, then only we'll know.
Okay.
When Mr. Gogoi is here, Ms. Vamna, kindly tell her. Yeah.
Malad, we are preferring to withdraw the petition lodged because there's been some amicable
Ms.
communication.
Das has serious objections. What do you say on that?
That I am not aware of.
The present interlocutory application, I heard Mr.
NZ Chaudhary.
N.Z. Chaudhary and Ms. P. Das. N.Z. Chaudhary, Learned Counsel for the petitioner, and Ms. P. Das, Learned Standing Counsel, Secondary Division Department. The applicant, who is the writ petitioner in WPC number 2692/2025, has instituted the present interlocutory application, praying for permission to withdraw the said writ petition. In the interlocutory application, the petitioner has contended that the respondent of that contended that it has been informed to him that the departmental authorities are presently considering the petitioner's order of suspension as well as institution of departmental proceedings against him, and he is under the belief that there would be some favorable order in his favor in the matter. Also, accordingly, it is submitted that the petitioner prays for withdrawal of the connected writ petition. Prayer is not objected to by your name.
P. Bhattacharya on behalf of B. Purkaista for respondent number 5, private respondent.
Mr. also reportedly here, Mr. B. Purkaista,
P. Bhattacharya on
B. Bhattacharya, Learned Counsel appearing for the opposite party number 5.
P. Bhattacharya on behalf of B. Purkaista.
So in view of the above, the petitioner is permitted to withdraw the connected writ petition being WPC number 2692/2025 with liberty to refile the same if the occasion so demands. Also, with the above observations and directions, the present interlocutory application stands disposed of. Thousand writ petitioner Likha. In view of the order passed today in I bracket C 2077/2026, permitting the petitioner to withdraw the present writ petition with liberty, the present writ petition stands dismissed on withdrawal with liberty to refile the same if the occasion so demands.
Much obliged.
Deeply obliged.
My notary also BTC also. BTC was main.
None appears for the parties on call. Registry to list this matter again.
No, sir, I am
the vacations on a date.
I am appealing for higher division for 1 and 2. I am appealing loss.
None appear for the petitioner. None appears for the petitioner on call. Mr. S. Bhuiyan, Learned Standing Council,
Higher education for 1 and 2, Lordship.
Standing Council, Higher Education.
For 1 and
application
2.
Respond number 1 and 2. There is no representation on behalf of the respondents number 3, 4, 5, 3, 4 and 5, 5, 6 and 7. Also, in view of the above, raise for the ends of justice, raise free to list this matter again after the ensuing summer vacations on a date to be fixed by it.
Deeply.
Heard Mr. P.P. Borua, Learned Counsel for the petitioner. Issue the petitioner. The present contempt petition has been instituted, alleging violation of the directions passed by order dated 13/10/2025 in WPC number 4110/2023. Also, issue notice returnable 4 weeks. Petitioner to take steps for service of notice upon the respondents by way of speed post. Steps within 3 working days from today. Register to list the matter after 4 weeks. Huh? Item number 15 or
14,
खाली change होबो order dates are
same.
खाली 15 और होबो WPC 935/2023 और 16 not होबो WPC 935/2023 দুটাতে একে WPC দে same 14, 15, 16 same. 15 or 16 on order dated 13/10/25 WPC number 935/2023. ठीक है सर?
Contempt application. Order is at page number 10. Authority court, page number 13. Lordship order is at page number 10. Start from page number 10. Cooperative court, page number 13. Paragraph 10.
So this was an order of 28/3/2025. Right?
There is a delay, my lord. Like with those.
How can we?
Lord, as per instruction of the
When did you serve? 8/4.
8/4.
So 2 months, 8/6. You filed this on?
File on 15 June. Lordship. In June. 7 days delay on.
Hut, Mr.
On behalf of Mr.
215 is there, so we can always invoke that power. Hut, Mr. D. Gugui, Learned Counsel for the petitioner. The present contempt petition has been instituted, alleging violation of the directions passed by this court-wide order dated 28/3/2025 in WPC number 4464/2024. Issue notice, baki eke thai. Respondents.
Sole respondent.
Sole respondent. Huh? Sole respondent. Eta asa.
Deeply honest.
In spite of there are 3 orders passed by the Honorable Court, the result of the petitioner has not been declared, my lord. Already in respect of others, on 13th May, result was declared. You lordship may direct the CBSC, my lord, to obtain. Otherwise, if you lordship.
Oh, that case.
Yes, my lord. Due to some issue, my lord. All avenues has been stopped, my lord, now for higher studies. After 2 interim order, I was allowed to sit in the practical and theory.
Now this coordinate bench has already
Yes, ma'am.
directed that they have not complied with
Not
it.
complied.
What is this?
If you lordship direct the.
Can you get Miss Ranu Bora?
Yes.
Get it. We'll see.
Your lordship, the matter pertains to the non-payment of arrears salary from 1/1/2015 to 14 July 2022, my lord.
Madam Buzarua,
Yes. The similar.
there are two regularizations.
Yes.
First one and second one.
Second
From
one.
second, you have been given. There is a coordinate bench judgment of my Lord
Yes.
Justice Borua.
Pending, my lord, before this court, and
Similar nature of two writ petition is pending before this.
No, that this issue has already been decided, that you will get it in terms of the second regularization.
Yes, my lord.
You see that judgment, because there are two, this is that WA 132,
132.
132 follow-up. So you were regularized with the first order,
Started to
then the second, there were cases filed, then the court said, no, it will be according to the second order, because that is the order with the concurrence of the Education Department, Government of Assam, Finance Department. On the prayer of Ms. A. Buzarburwa, registry to list this matter again on 17/7/2026. I want to disturb you before vacation, after vacation.
Mayor Vijay. Is a top down of litigation also in spite of court's direction also. Till that they have not taken any decision. The grievance of the petitioner is that also, although there are sufficient number of students, more than 210 students, one additional post is required to be sanctioned in view of the RT Act and as well as the section 311 lordship. That is not done lordship. But in the earlier two direction lordship, there is specific direction to the director to take a call on that issue lordship. But
No, after the order was passed by this court,
yes, lordship.
huh?
Yes, that is on 16/10/2023.
What happened?
Thereafter, lordship, they have simply a communication letter is made that lordship will find at annexure 23 page 76.
I'm having it.
The director is requested to furnish.
What
a
happened
detailed
after
report.
this?
Thereafter, no steps is taken, lordship.
Yes, madam.
Madam, will be taken on Friday, my lord.
Miss N. Fukan, learned counsel, learned standing, heard Mr. A. Deka, learned counsel for the petition. Also heard Miss N. Fukan, learned counsel, learned standing counsel, elementary.
Elementary, lordship.
Ms. Fukan submits that she be granted some time to receive instructions as to the steps taken steps taken in the matter after the passing of the order dated 16/10/2023 by this court in WPC number 6110/2023. Pray accepted. Registry to list this matter again on 15/7/2026. You get that instruction. That much only, nothing more. What have you done? Clear cut direction
Yes.
311, 111 to be followed.
Yes.
That's it.
Deeply obliged.
None appears for the petition on call. Ms. P. Das, learned standing counsel, secondary education is present. For the ends of justice, registry to list this matter again on 17/7/2026.
Deeply obliged.
Somebody was there, we could have disposed of this matter. Nothing is it. Is there a restriction placed by the education department outside, not allowing the petitioner councils to come in? Huh? Nobody is there. Miss Chutia, Miss Das, you think you have done something outside? Okay, order.
It is a lordship. This third round of litigation, my lord. First round of litigation.
Any order passed in pursuance to the directions passed by this coordinate bench at page 658?
No, my lord. Till no order has been passed, but my lord, the impugn order, those will see, page 63. This order was communicated on 4th of June. On 4th of June, in the earlier round of litigation, my lord, while filing the affidavit in opposition on 2nd of December 2025, nothing was mentioned regarding this letter.
Okay.
Nothing was mentioned. Only after communicating the order,
There we
this
should be.
was, my lord, communicated to the principal. And accordingly, my lord, at page 64, the principal has forwarded the letter to me, my lord.
What is this? Heard Mr. Ayat Soika, Learned Counsel for the petition. Also heard Ms. P. Das, Learned Standing Counsel, Secondary Education Department.
Here, your lordship, respondent number 4 is the principal. So here notice may needed to do, your lordship.
What do you have to say on the orders passed by this court not being complied with?
For that, your lordship, I may allow to obtain instruction.
You have a copy of the writ petition. No. You don't serve copies to them.
We have served. We have served. Just serving money, we cannot file.
That's it.
You misplace koi sa magi koi.
Why not?
Where is the 6/6/2024?
Page 47, my lord.
47. Also, the petitioner being aggrieved by an order dated 6/6/2024 issued by the Secretary to the Government of Assam, Department of School Education, rejecting the claim of the petitioner for being authorized her salaries, the petitioner had approached this court assailing the same by way of instituting a writ petition being WPC number 3482/2024. A coordinate bench of this court, wide order dated 27/5/2026, proceeded to dispose of the said writ petition with the following direction. Page 62, A to A. Also, the said order, it is contended by the Learned Counsel for the petitioner that the said order dated, certified copy of the said order dated 27/5/2026 being furnished to the respondent authorities, the petitioner was served with a copy of a communication dated 2/9/2025, wherein the wherein the Director of Secondary Education Assam had directed the principal Paradhora Higher Secondary School to forbid the petitioner from holding any more classes in the school with immediate effect. It is contended by the Learned Counsel for the petitioner that the said communication was never brought to the notice of this court in the earlier round of litigations. Also, he further submits that the copy of the said communication was served to the principal. When was it, sir? On 4/6/2026, and thereafter the principal had forwarded the copy of the same to the petitioner. So, in view of the above, Mr. Soike, the Learned Counsel for the petitioner has further submitted that the directions passed by this court wide order dated 27/5/2026 has also not been complied with. Also, issue notice returnable 4 weeks. Ms. P. Das accepts notice on behalf of respondent number 1, 2, 3, 1, 2, and 3.
1, 2, 3.
No formal notice. Petitioner to take steps for service of notice upon respondent number 4 by way of speed post as well as by way of dusty mode routed through the registry of this court. In the event the notice is served upon the respondent number 4 by way of dusty mode, petitioner to file an affidavit thereafter. So, considering the projections made in the present writ petition, this court directs that till the next returnable date, the effect and operation of the communication dated 2/9/2025 shall remain suspended. Shall remain stayed. And again, till the next returnable date, the Communication dated 2/9/2025 shall remain stale. Awesome.
Petitioner shall be allowed to continue.
That is there. Come back, we'll see.
Obliged, my lord.
Deeply obliged.
But all said and done, how were you appointed in a provincialized school?
Ad hoc
That is
basis
true,
is
my lord,
your
but my
lordship.
Madam, there are orders passed by this court.
Yes, sir.
Comply with that then too. How can you just issue a backdated order?
Back.
Withdraw this, do what is required. We will not come in. But if we have to come in, it will be very bad.
Obliged.
I'm deeply obliged.
Lordship, kindly pass over the matter for time being.
So, my lord, I prepared a chart, but among the 7 petitions.
5, there is no particulars.
My lord, particulars for one, I don't find that others have the particulars are there given, my lord. My lord, as regards one of the petitioner that I could contact, he said that we have got everything. Others, I don't know.
Your basic case is that they should be given it from 2011.
11.
But in this sketchy matters, how can we approach the government? We will direct. And with regard to your that enhancement thing, that is that you can press. But Mr. P.K. Roy Chaudhary, Learned Senior Counsel, assisted by Mr.
Yes, sir.
S. Ahmed, Learned Counsel for the petitioner. Anybody for the respondents? None has appeared for the respondents. So, the petitioners, by way of instituting the present writ petition, has prayed for grant of financial upgradation benefits under the Assured Carrier Progression Scheme, ACPS, bracket ACPS, to the petitioners number 1, 3, 4, and 7 with effect from 1/1/2011, and in to the petitioners in respect of all the 1, 2, 3, to the petitioners with effect from 1/1/2011, as projected in the writ petition on the implementation of the Assured Carrier Progression Scheme, bracket ACPS, wide notification dated 25/5/2011. Some of the petitioners in the present writ petition were granted the first financial upgradation. However, the said upgradation was so granted to them with effect from 1/5/2014. So it is contended that in terms of the notification dated 25/5/2011, the first financial upgradation on conclusion of 10 years of service is to be so authorized to the person concerned with effect from 1/1/2011. So the petitioners submit that they, having completed their 10 years of service prior to 1/1/2011, in terms of the notification dated 25/5/2011, they are required to be authorized there such first a financial upgradation benefit under the ACPS scheme with effect from 1/1/2011. Accordingly, it is submitted. It is further projected that in respect of the petitioners number 2, petitioners number 5, 2, 5, and 6, no financial upgradation benefits have been granted to them, although they fulfill all the requisite requisite eligibility criteria for being authorized, authorize their first financial upgradation benefits on completion of 10 years of service with effect from 1/1/2011. Mr. P.K. Roy Chaudhary, learned counsel for the petitioner, has submitted, after reiterating the facts noticed herein above, has submitted that the petitioners in the present writ petition has also prayed for an implementation of the recommendations made by the Anomaly Committee 2010 in respect of enhancement of the grid pay of the sub-registrars and senior sub-registrars. However, he submits that the present petition be confined only to the benefit of assured career progression scheme prayed for by the petitioner, and the issue with regard to implementation of the anomalies committee's report is not being pressed herein. Full stop. Mr. Chaudhary has submitted that the petitioners who were granted that the petitioners number 1, 3, 4, and 7 who were authorized their first financial upgradation benefit under the ACPS scheme were so authorized this benefit only with effect from 1/5/2014. He submits that the said benefit ought to have been authorized to the petitioners with effect from 1/1/2011. He further submits that in the affidavits filed by the respondents, no reasons have been assigned as to why the petitioners, more particularly the petitioners number 1, 3, 4, and 7, were so authorized their first financial upgradation benefits under the ACPS scheme with effect from 1/5/2014 and not from 1/1/2011. Also, upon hearing the learned counsel for the petitioner, this court, in absence of any adequate reasons being assigned by the respondent authorities in the affidavits filed by them, finds that the materials requisite for adjudication of the issue raised in the present petition is absent. Also, considering that the grievance of the petitioner is with regard to grant of financial upgradation benefits, this court, in view of the situation emanating in the matter, in absence of a categorical stand taken by the respondents herein, requires the petitioners number 1, 3, 4, and 7 to approach the respondent authorities with a prayer for being authorized their financial upgradation benefits with effect from 1/11/2011. In the event of such representation being filed by the petitioners number 1, 3, 4, and 7, the respondent authorities shall consider the same, and in the event it is found that the petitioners fulfills the eligibility criteria as set out wide the notification dated 25/5/2011, which had introduced the assured career progression scheme, the petitioners shall be granted their first financial upgradation on conclusion of 10 years of service with effect from 1/1/2011 with all consequential benefits. So, insofar as the petitioners number 3, 4, 2, 5, and 6 is concerned, no particulars having been brought on record with regard to receipt by them of their financial upgradation benefits under the ACPS scheme, this court requires the petitioners number 2, 5, and 6 to approach the respondent authorities by way of submitting individual representations, staking a claim for being authorized their first financial upgradation benefits under the ACPS scheme which was so notified by notification dated 19/6 to, no, 25/5/2011. On receipt of such representations from the said petitioners, the respondent authorities shall consider the same, and in the event the petitioners number 2, 5, and 6 are found to have satisfied the eligibility criteria as set out in the SCPS scheme, the respondent authority shall authorize to the petitioners number 2, 5, and 6 their first financial upgradation benefits under the SCPS scheme with effect from 1/1/2011 with all consequential benefits. Also, the petitioners to submit their respective representations within a period of 1 month from today, along with a certified copy of this order. Also, on receipt of such representations from the petitioners above named petitioners, the respondent authorities shall dispose of the same within a further period of 2 months from the date of receipt of such representation, wide representation. Also, by way of a speaking order. Also, with the above observations and directions, the present petition stands disposed of.
I'm appealing for number 1 to 4. Revenue Department.
Mr. S. Doctor. None appears for litigation, appears for respondent number 1 to 4.
1 to
Any
4.
other respondent?
Finance Department. also there.
None appears for respondents number 5. None appears for the respondent number 5.
Lordship, kindly pass over the matter for time being.
Why?
My senior is present another courtroom.
But where is the affidavit? He filed an affidavit. Why? He had undertaken that he will file an affidavit. Discharge orders on record. Why? Why the discharge orders are not on record? After some time. Yes. Yes.
Yes, Lordship. This is regarding to departmental proceeding, Lordship. And 4 charges was, 4 charges there, Lordship, against the petitioner.
You have
And-
anything more to submit?
No, Your Lordship. I've prepared a written argument as well.
And all charges are proved by the, as per the witness of the witness petition, prosecution witness number 3 and 5, Lordship. Kindly come to page 46 of writ petition.
PW 3
witness,
and PW?
PW 3, 5, and 9, Lordship. And all witnesses are said that he submitted false bill of Madhuri Hotel, and he take away the TADA bill and ran away
How
from
does
the.
that charge then? If that bill is
Yes.
not there, what have you proved?
Yes, Lordship, from the prosecution witness PW 5, Lordship, Motilal.
PW 5.
Yes, for place 46 of writ petition, Lordship. May I read? as per the statement of so and so, Motilal has been serving in this unit since 10/4/2017. Presently, he is serving in the account section in office unit. At about 18:30 hours, 29/2017, Pradeep Balhara came to the unit office, and while saying that he was suffering from piles and he had to go to local NEPCO hospital for taking injection, requested head clerk Amit Kumar for arranging the help of someone in this act, whereupon clerk Amit Kumar asked him, that is Motilal, to accompany him. When both of them went to hospital, they found the hospital closed, and thereafter they proceeded towards the office, but Pradeep Balhara stopped near the bank of the way and he came back to office. About 5 minutes later, Pradeep Balhara came to him in the office and asked him whether his temporary duty bill was prepared or not, whereupon he replied affirmative. Having heard the answer, he asked him to show the same. With the permission of head clerk Amit Kumar, he showed the TADA register, wherein there was 2 TADA claims of one Numaligarh tour and the other of Kolkata tour. And the Numaligarh bill was passed. The TADA for Kolkata was not prepared. Then the charge official asked why the bill for Kolkata tour was not prepared and asked him to show the same. He took the premises of head clerk to show the TADA claim form related to Kolkata tour, opened the concerned file and showed him, whereupon the charge official opened the form at the top and started reading the same. The charge official was standing and moved to the chair lying nearby to read the paper sitting on the chair, but instead of sitting on the chair, he went outside in haste. He immediately informed head clerk Amit Kumar that SI has left with the TADA form of his Kolkata temporary duty, whereupon all the persons present in the office, Motilal, so and so, has her and others went up to the main gate of the unit office, but it was dark outside and the charge official was not seen. He take away the TADA bill and he come to the office with an intention to dispose the TADA bill, and he success on that, and he take away the bills. It is submitted by the PWD 5 and 9, all submitted the same, lordship. Then then kindly come to page 48. From top, the 4th line. Second paragraph, during the cross-examination. During the cross-examination. May I read, lordship?
No, it's okay. Okay, anything more?
Then PWD 9 also same at 53, page 53. First paragraph, from 1, 2, 3, 4, 5, 6, 9th line. The charge official, from charge official. The charge official went from this unit to take.
Okay.
And after that, the petition with 5 and 9 produced the Madhuri House bill, Xerox copy of Madhuri House bill. That is on record, let's say. But original TADA bill and
that is not.
That is gone. And in that bill, petitioner put his signature upon the customer's plate.
Right.
And the petition and that PWD witnesses, that documents exhibits, petitioner put his signature, lords. That is on record, lordship.
Okay.
And
that is there at page 15, but the signature is not clear.
Signature is not clean, and that is on the record. And last, at the time, regarding the witness of Bipin.
You give me a small note, whatever you have to say.
Yes,
Small
lordship.
note.
Yes, lordship.
Like Miss
Yes,
Shiva has already given. Huh? Give me a small note.
Yes, lordship.
We'll have it immediately. We'll pass the orders.
Yes, lordship.
Can you give it to me before vacations?
Before vacation on
Friday also you can do.
Yes, yes, yes.
Hardik, Learned
No, I
Council.
apologize, I was on legs.
No, no, it's okay. You have got it. Hardik, Learned Council for the parties at some link. Hearing remains, I'm just putting it as hearing remains inconclusive. I'll pass the orders.
Yes, yes. Records, sir, should be produced, Lordship, next day.
You can keep the records with you.
Yes,
If
yes.
required, we will seek it.
Lordships, we had checked up the records in the meanwhile. That particular document has not been adduced as evidence by either side.
Which one that?
That verification which they had by Mr. Brijesh Kumar.
But
That report has not come.
that not there, but Lordship, at the.
No, they have relied upon it. The inquiry officer has relied upon it. But it was not adduced as evidence either by any of the prosecution witnesses, or it was not annexed to the memorandum of charges, Your Lordships.
And have you taken that point in your?
Yes, Your Lordship. Yes.
But at the time of hearing cross-examination, Lordship, petitioner was asked that whether any witness or other documents have been produced by the petitioner or not. That is not. He says then on page 222 of writ petition, Lordship, kindly have a look on.
You give it to me in writing.
Yes, Lordship.
তাকে একটা কপি দিলাম একটু আমার তুমি যেটা বলো না আমাকে দিদি এটা ঠিক আছে Lordship is fixing it this month or next month?
This month it might be. We'll have it on 16th.
16?
It's for delivery of orders. I don't want to hear
16?
it. I'll just pass the orders on that.
No.
16/7/2020. Yeah. Heard, hearing remains inconclusive. Registered to list this matter again on 16/7/2020. It is by slip, Didiba. Written argument to Palek.
Deeply obliged. Deeply obliged.
Yes.
That matter, my lord. No liability. Those papers have been issued, my lord, already.
Everything done.
Done, my lord.
Madam, we have not got the pension or any other.
I can give him copies. Your lordship had passed order on 24th of April.
Who is appearing for the AG? You are appearing? For Mr. R.K. Talukdar?
But one of our prayers is for interest, my lord. We retired in 2000. Smile.
Heard Mr. P.D. Nair, Learned Senior Counsel, appearing for the petition, assisted by Mr. P.D. Nair, Learned Senior Counsel, assisted by Mr. H. Chetri, Learned Counsel for the petitioner. Also heard Mr. B.D. Goswami, Learned Counsel, appearing for respondent number?
Number 5, 6 and 7.
5, 6 and 7. And Mr. D. Upamanyu, Learned Standing Counsel, the Higher Education Department. Miss
R.K. Talukdar.
For Mr. He is here in court today.
Yes, sure.
R.K. Talukdar, Learned Standing Counsel, AG. Madam. Miss R.M. Borua, Learned Counsel, appearing on behalf of respondent number 3 and 10. Mr. B.D. Goswami has placed before this court a set of instructions received by him. A perusal of the same reveals that the authorities of Dudhnoi College, Dudhnoi, has already forwarded the pension proposal in respect of the petition to the Accountant General bracketed A&E, Assam, while a communication dated 10/5/2026 and had therein enclosed a non-liability certificate. It is also revealed that a proposal for authorization to the petitioner, leave encashment benefits has also been forwarded. Full stop. As the pension proposals have now been forwarded to the Accountant General bracketed A&E Assam, Mr. R.K. Talukdar on the next date of listing shall apprise this court about the further processing done in the matter. So that is directed that in the event the proposals are submitted in respect of the petitioners are complete in all respect, the Accountant General shall proceed to finalize the same and release authorized to the petitioner his pension, due pension and pensionary benefits, including leave encashment before the next date of listing. To facilitate the said exercise, completion of the said exercise by the Office of the Accountant General bracketed A&E Assam, registry to list this matter again. Today is 22. Oh, Aji 22. We'll give them 45 days time. On 7/8/2026.
That could be on the Friday, Monday thereafter.
10/8/2026.
So the leave encashment and gratuity, pensionary benefits, including gratuities.
No, the pensionary benefits will come everything. It'll also be gratuity, leave pensionary benefits, including gratuity, comma, leave encashment, etc.
Deeply observed.
Please, your lordship, I am praying on behalf of Meera Bora. She is legs on court number 7, lordship. She is legs on court number 7.
Who?
Meera Bora.
Huh?
Meera Bora. M. Bora.
Okay. As agreed to as prayed for by the Learned Council for the parties, registry to list this matter again on 27/2026.
For the time being only for it.
Today there is a matter around 70 matters. How many matters will I? This is nothing urgent. It can be done after vacations also.
Lordship, kindly, I am not in this case, lordship. I am also.
Last night. How about continue? एकदम उठा था मुझे माटी में. Yeah. Why the results are now? What is this childish play going on?
Yes, Lordship, I am talking to them also to declare the
not
result
done.
also.
Boy, there was something. We passed some orders.
Yes, yes.
You allowed him, then the coordinate bench has passed this order.
Yes.
Now you sit over the results.
Now they have said, regional officials now I have bring
Huh.
in. They said that the matter is in a Delhi, Lordship.
Delhi
So,
for what?
Delhi headquarter, Delhi.
Huh?
Delhi headquarter, CBSE
No,
headquarter.
what is Delhi headquarters? They'll have to approve it.
Yes,
Huh?
they will have to approve.
How
it.
long will it take?
Our Lordship, they had said that mark sheet already prepared. So they will
Okay, place it on record on Thursday.
Thursday. Yes.
As
Take instruction.
prayed for by the learned. First, considering the nature of the directions, violation of which has been prayed for in the present writ petition, this court had requested Ms. R. Bora, learned Standing Counsel, Central Board of Secondary Education, to receive her instructions in the matter. Ms. Bora has submitted that the matter be taken up on Thursday, by which date she will complete her instructions and apprise this court with regard to the status of compliance of the directions passed by this court via the order dated
22/5/2026.
22/5/2026 in WPC number 884/2020. Please see that.
Yes. Oblige.
Young boy.
I know.
He gets
Lordship.
something,
I have
let him
also
get it.
told him. I have to request him.
Where is that order of the director?
Yes, that is in the record, Lordship. I have a copy also.
Date.
Lordship, dated 15/6/2026.
No, that is that he will take instructions.
Yes, now
Thereafter,
the director said that The petitioner were,
No, where is that order of the director? Page? It was not placed before this court.
it was placed last occasion also. On the, after perusing that,
Oh, I remember,
Order.
that's why, but I did not find the copy yesterday.
May please your lordship, my lord. Did I pray for some accommodation on Friday, my lord?
the necessity of instruction arrival, this instruction of.
Yes, what?
My lord, I misplaced my file. That's why, my lord, I seek some accommodation on Friday. I have to reconstruct the file, my lord.
Only lordship where instruction they are supposed to be placed. In fact, the matter was heard by your lordship. Only to that effect, lordship.
I only missed out on this. Yes, what is the qualification for library assistant?
না গালি নাপাৰিব তেনেকে দুজনী ফল বুলি গালি পাৰিব নেকি আপুনি?
Okay, she does not have, he has a graduate qualification.
Yes.
He does not have the diploma. He'll be tutor. What more is required? He'll be tutor. You have gone to 10 places to collect this. Now we will now examine in other institutions, library assistants, what was the qualification you followed? And if we find that you have not done this exercise there, we'll haul you up here again.
Regarding the library assistant, there may not be.
There
a
is no
tutor.
qualification prescribed in the rules.
Yes.
Huh?
Yes.
You have gone to 10 places, you have collected it.
Yes.
Now I am going to direct you to place.
Yes.
Last 5 years, the colleges wherein you have regularized, provincialized library assistant, the qualification you have followed. Place it before me by day after. You have written here. We'll see how you have complied with
After
that.
vacation, my lord.
No, not after vacation. Day after tomorrow. What is this?
Day after tomorrow, my
You
lord. I
go
will
to
go there.
recognition of junior colleges. You go here, you go there. He is a graduate, no doubt about it. He'll be tutor maximum.
But in case
What
of
is
library
this?
assistants,
Trying to lead the court on a way which is it's not to go. What is the qualification?
My lord, at that time, he was higher secondary. In the year 2000, he obtained graduation.
On the date when the college was provincialized, were you a graduate?
Yes, yes, yes. Because as per rule also, lordship, it should be lordship qualification.
Mr. Sharma, get that instruction that you have followed this in letter in other colleges, other junior colleges.
Yes, I can.
I'll dismiss the petition. Don't worry. Just satisfy me with that. When? Day after?
Day after tomorrow, I will not be here, my lord, because some.
Ambubasi.
Yes, Ambubasi problem is there.
When are you coming back?
Moreover,
26?
roads are completely blocked.
26? I can understand that.
26 also not possible.
27? 27 to Bondo.
27, my lord.
26 is the last court.
Okay. Mr. U. Sharma, learned standing counsel, Secondary Education Department, has placed on record and instructions received by him from the Director of Secondary Education. A perusal of the said instructions would go to reveal that there is no qualification prescribed for the post of assistant librarian in the Assam Education Provincialization of Services of Non-Teaching Staff of Venture Educational Institution Act 2018. Accordingly, the Director has projected that the qualifications as maintained, as highlighted, as stipulated in the regulations on recognition of higher secondary schools and junior colleges is required to be followed. Further, it is projected that in the Assam Secondary Education Provincialized Schools Rules 2018, the qualification of a library assistant is so stipulated as graduate in any discipline from a recognized university with a diploma in library science. So, Mr. Sharma, on the next date of listing, shall place before this court the provincialization of library assistants in other higher secondary junior, in other senior secondary and equivalent schools under the Act of 2018, wherein the library assistant so provincialized as teacher/tutor was provincialized after it was satisfied that the person concerned had a graduate degree along with a diploma in library science. Instances of at least 10 such schools be placed on record. The petitioner is also granted liberty to bring on record provincialization of services affected in respect of library assistants without having the qualification of diploma in library science. Registrate to list this matter again on 17/7/20. What does it mean? 17/7/2026. A copy of the communication dated instructions furnished by Mr. Sharma is kept on record and marked as X for the purpose of identification.
For further hearing.
For further hearing. Mr. Sharma, get it, and you also give me.
Lordship, Senior Counsel Mr. S. Board is on legs. Can it be taken up after some time?
Lordship, here in this matter, we were directed to place a record, Lordship. Your Lordship may give me 2 more days, Lordship. I will
Why?
place it. I have made the communication, Lordship, with the IS.
Who has
with
not?
the-
When have you made the communication?
No.
When did you make that communication?
Lordship, today only, there was a delay from my side, and my apologies, Lordship.
Okay, as prayed for by Miss. You are appearing for?
Respondent number 1, 2, and 4, Lordship, secondary education.
Standing Counsel, Secondary Education
Lordship.
Department. Registered to list this matter again on 24.
Lordship.
Let's sleep corridor 24 for production of the relevant records. 24. Okay. 24/6.
Please, Your Lordship. I've had very limited prayer, Your Lordship. Petitioners, since 2012, she has been working honorary basis, Your Lordship. But here,
Honorary in a provincialized institution.
provincialized.
How can that be?
as per the governing body resolution, Your Lordship.
Governing body does not have any power.
But she's at till date, Your Lordship, she has been. Earlier occasion, Your Lordship.
If I interfere, following the earlier decisions of this court, gone.
And since Your Lordship already, although this decision has been opened.
Mr. Counsel, you have said that you were engaged because on compassionate grounds. Governing body is no authority to do that, one. Two, it was already a provincialized college.
Yes, Your Lordship.
Now-
Since there is a post vacant, Your Lordship.
You appear for direct recruitment, get it.
In that case, Your Lordship.
On the prayer
only a
of the
direction,
learned
Your
counsel for
Lordship.
the petitioner.
Only
request
direction,
to
Your
list
Lordship,
this
if
matter.
the advertisement issued my candidature may be considered, Your Lordship. That observation, because since 2012, she has been.
Sister, I can't do that, which I can't do legally. Why should I do illegally? How can you ask me to do that, pass that on? Not disturbing you before vacations, come back after vacations. As prayed for by the learned counsel for the petitioner, registry to list this matter immediately after the ensuing summer vacations.
Okay.
I don't want to disturb you during the vacations. Enjoy your vacations.
Lordship, here in this matter, I have received instructions from the department, Lordship. The petitioner is getting the GIS, Lordship. It has been sanctioned on.
Leave encashment?
Leave encashment, Lordship. The college has already sent us a proposal, but this time also they have not issued the non-liability certificate, Lordship.
Yes.
It is mandatory,
What
Lordship.
is this happening?
This is my instruction, Lordship. Since they are having some.
For the timing.
Huh?
Lordship,
We
may,
have given the, my lord.
the third point, Lordship, may just kindly bear us, the third point. They have forwarded the proposal, but without the long.
Cannot, because they find liability. The lordship has made an inquiry, whether non-liability is my lord, a condition precedent for granting this.
Yes.
My lord, we have said, we have given the proposal, except the non-liability, we cannot, because we find liability, lordship find.
Then where is the proposal to institute proceedings? You finding liability and sitting over the matter will
My
not
lord,
do.
we have read it to the government, they are not taking.
You have to give, no, you have to take a proposal. You have to.
No, we have asked for, the lordship will kindly have a look over this. We have written about this letter to the director. We cannot keep the non-liability, my lord.
Okay. Mr. Hardy Learned Counsel for the parties at some length. Registry to list this matter again on 21/7/2020. All of khali thaka din diya 22/7/2026. The instructions furnished by the Learned Counsel for the respondents are kept on record and marked as X and Y for the purpose of identification. We'll hear the matter on the.
Yes.
Highly obvious.
In this case, my lordship directed us to file affidavit. Our affidavit is ready, lordship. Even lordship, yesterday evening we have sent it for vetting, lordship. This is our affidavit. But so lordship,
Okay.
which time, lordship?
Okay. Mr. After the questions. On the prayer of Mr. K. Gogoi, Learned Standing Counsel, Dibrugarh University, registry to list this matter again on 22/7/2026. In the meanwhile, the petition respondent university shall invariably bring on record their stand by way of filing an affidavit. Mr. Gogoi,
Before,
that you are
lordship,
here.
I apologize, lordship. One item.
No, it's not nothing to apologize, because see, item number 8.
Four, lordship. Four.
I passed the order
Lordship.
and I had disposed of the writ petition.
Lordship.
Then somehow going through the papers, I found the age of the petitioner.
Lordship.
Petitioner's age is 69
Lordship.
in 2017.
Lordship.
So 68 in 2016. You have now modified that penalty from 2004 to 2016. Now in 2016, he is already retired.
It's a continuation of the lordship earlier.
No,
proceeding.
cannot be.
It's a continuation.
Cannot be. That earlier order was interfered by this court.
No, that court also give a liberty as to lordship the.
Liberty afresh.
Lordship.
So that order is gone.
Lordship.
Fresh exercise. If he has retired, how can you impose this penalty? It can only be with regard to withholding of pension. I had literally.
Otherwise a continuation of lordship.
No, it cannot be.
Lordship.
Whether you show me you have a power to deem that the person will continue in service, although retired, for the purpose of, that is not there. How can it be?
That power, statute never that power
I
prescribed.
had quoted everything done, then I interfered with the penalty and said that it will be 2 increments like Kamleshwar Dutt. I found that the charges are the same. Allegations are same. I had converted that to that. But then I found that this, I stopped it. Then I said, get it for listing. Mr. Dotto is not here. He'll be coming tomorrow.
Posted it any day, lordship, this week or after vacation?
No, I will have it on Wednesday.
Wednesday, lordship.
Wednesday, you just go through that. If you say that it can be continued, he can be held to be an employee even after, that's a possibility, but it has to be there somewhere in your rule.
Rule, lordship, that part is.
That's just check up.
That part is.
If not, I'll deliver this order.
Lordship.
This matter was reserved for judgment. So, while passing the order, while passing the final order in the matter, this court found that the petitioner had already superannuated from his services sometime in the year 2009. So, the penalty of compulsory retirement was imposed on modification of the earlier penalty so imposed, with effect from 10/11/2016. This court finds that on 10/11/2016, the petitioner was not continuing as an employee of the university, and accordingly, the said penalty may not be permissible to be so imposed upon the petitioner. So, in view of the above, the learned counsel for the parties are directed to make their further submissions in the matter on the said issue on Thursday, 25, on 25/6/2026. Registered to list this matter for further hearing on 25/6/2026.
Then, lordship, I have also, my mind also that part.
That part, my mind never, because
but lordship, senior counsel not indicated that.
Not saying no pleadings to that effect.
That part, no, when pleadings is there not indicated, lordship, my mind also that.
But what I find is, when it came to my notice, I just stopped. Because 2016, I was proceeding. Oh, 2016, you have passed the order. That means he is in service. Right. It occur to me also, my mistake. It also did not occur to me that whether he has retired.
Even lordship, when I've gone through the brief, lordship, then my mind was that particular point, lordship. But he has not indicated. Even lordship, now pleading
Doctor may have just missed out. We'll tell him.
Lordship.
Because if I pass that order, it will be an illegal order.
Lordship. Oblige, lordship.
In this matter, we have received our instructions, my lord. We'll be filing an affidavit. So the matter can be taken up, my lord, immediately after the vacation, my lord. Otherwise, my lord, there is, my lord, the petition, my lord, after 12 years, they filed, my lord.
Mr. Mahmood.
Yes.
Your case is that #1 Salabila LP School dice code was taken.
No, Salabalia Nagoriabara LP School's dice code has been taken by Salabalia LP School.
But this has happened in 2013. What made you wait till 2013?
No, in 2014, school was provincialized.
13.
And 14, I have filed RTI petition.
Okay, fine, you filed. But why did you not assail that?
No.
RTI petition cannot take 10 years.
No, because how they got their school provincialized, we had no idea.
You should have filed an appeal. You should have filed an appeal.
Under 2017 Act?
No, not under, this was under 2017 Act. No, this is under 2011 Act. You have not done anything.
11 Act has been struck down already.
Oh, when the provincialization was done, it was done under 2011 Act.
There are several representations I have filed, and RTA applications was filed that first that Lordship may kindly see page 26. Because I did not get certain informations without knowing the everything clearly, how can I proceed on? Then, my lord, I again filed petition that Lordship may
Now
kindly
show
see
me
page
that.
38.
Okay, huh?
Page 38 kindly see.
38.
They are writing to their officers that something is wrong. And this,
Okay, show me your dice code was used.
yes,
Where do I get that?
my dice code was used, my lord, they,
That's an allegation. Where do I get the material?
yes, my school's dice code, that let me show, my lord, my dice code may be seen.
You are appearing for the private respondent.
Kindly see page 26.
You are in which school? Salia Bila number 1 or Salia Bila Nagriapara?
I am Nagariapara Rohima Khatun.
Rukia?
Rohima Khatun.
No, you're Rukia.
So my dice code,
Page.
page 26. In affidavit, my lord, they have not denied that they have not taken our dice code in order to get their school provincial. They have not denied this. They are saying only delay point. Now there is
The two persons is Mokok Furalil Ahmed and Rukia Khatun.
yes.
And why only against Rukia Khatun you have come, not against?
Because that person is no longer there.
Huh?
That person is no longer in that school.
Where is he?
He has perhaps got some another job.
His provincialization was not affected in his case.
My provincialization is not affected.
No. His provincialization was not affected.
That, my lord, it is told that he has got some other job.
Where have you said that? And with this disputed things, why should we come in? You go before the tribunal.
No, there is no dispute. Dispute has been created only for the sake of dispute. Kindly say, let me.
No, you show me some material that
Yes.
this is actually a provincialization of number 1 Saliabala Nagriapara.
Number 1 Salabila Nagariapara LP school. And my school has got the dice code in the year 2007-8. Can you see page 26? Page 26. Number 1 Rohima Khatun.
Come to page 24. This is the inquiry report.
Yes, inquiry report in favor of my school.
Rohima is you.
Yes.
Okay. Heard Mr. M.U. Mahmood, Learned Counsel for the petition. Also heard Mr. A. Fukun, Learned Standing Counsel. Elementary.
There are other inspection report also in my favor.
Mr. Fukun submits that he would file an affidavit on behalf of the respondents represented by him on or before.
Immediately after the vacation, 1 week.
On or before 17/7/2026. A registry to list this matter on 24/7/2026. The respondents in the affidavit shall also highlight as to the dice code utilized for the purpose of provincializing the services of the respondent number 6. Also. Date disorder.
May I please, Your Lordship? Your Lordship, in this matter, Your Lordship, the petitioner is praying for regularization, Your Lordship, as a bearer, Your Lordship, in the Department of.
So maybe scheme.
Your Lordship.
Scheme for regularization.
Yes, Your Lordship. There is no such a scheme, Your Lordship.
Without a scheme, how can you be regularized?
Your Lordship, my only humble contention is that, Your Lordship.
This is a direct recruitment post. You appeared in a selection, you plugged.
Yes, Your Lordship.
That is not the challenge.
That is the statement which I have made, Your Lordship. But however, that would not bar me to
show me the
debar
law.
me
Show
from
me
regularization,
the
Your Lordship.
provision, Mr. Deka, for provincialization. Supreme Court in Suvendu Bachchaji said that in the state, regularization is only in respect of casual workers MR workers, work charge who were there from prior to 1/4/93.
Yes, Your Lordship. I'm only relying on Jaggu, Your Lordship, because
That
my
will not automatically give you everything. There has to be a basis,
yes,
a scope. Show me that.
Your Lordship, my only humble contention
Otherwise,
is
we are
this
dismissing
petition.
your writ petition.
Your Lordship, against them, there is no dispute, Your Lordship, that I have participated in the recruitment process, Your Lordship.
That
I
is
was
not under
selected.
challenge here. We will not go
Yes,
into
Your
that.
Lordship. However, Your Lordship,
Whenever
my
the
long.
posts are advertised, you participate, we'll ask them to give you some weightage, which they have already given.
Yes, Your Lordship. So my appointment was made by a selection board, Your Lordship.
Fine.
On the basis of an application, on the basis of an interview that was being conducted, Your Lordship, in the
Yes,
year
Mr. Nair, what do you have
2011,
to
Your
say?
Lordship.
He participated in the selection. We have given him the weightage. my lord.
Weightage.
Yes, Your Lordship.
That will be continued to be given the next round of next selection also. Regularization, we don't find any scheme.
Your Lordship, I am only here with respect to my regularization as a bearer, Your Lordship, which can be created by way of
Why should
creating a
we direct them
temporary
to
post, Your Lordship.
unnecessarily create a post?
Your Lordship, I have discharged my duties for
You,
more than
you,
12
you
years, Your
appear
Lordship.
in the selection. If you get selected, we'll ask them to give you a relaxation.
Your Lordship, the
We need not
selection
ask you
process.
because they have already there. I'm sorry. Otherwise, for this short tenure of service, we will
Your
not
Lordship,
proceed.
13 years of service, Your
13
Lordship.
years is nothing. There are 30 years pending.
Yes, Your Lordship.
Then-
Then Your Lordship may fix it after vacation, Your
No,
Lordship. I'll
today.
satisfy Your Lordship.
Today.
I'll satisfy on that issue, Your Lordship.
We have already considered him. We have given him the marks, my lord.
That's the
And in
final.
fact, the cutoff was 52.
Yes, sir.
He
He did
secured-
not get it.
He got,
Even
he got
after
21.
the infusion of the
Yes.
weightage marks.
Yes, Your Lordship.
Fine.
That was not being put into challenge, Your Lordship.
We are not
I'm
challenged.
only here that my
You
consideration for
withdraw this
regulation is
challenge
considered.
that we'll consider that challenge.
Then, Your Lordship, my representation may be considered, Your Lordship. That is also one of my
No.
prayers, Your Lordship. Then, Your Lordship, may fix it after
This
vacation.
is not a post office.
No, Your Lordship. I-
You withdraw this, or we will say now you're not made out a case for consideration of your, because regularization is not for the asking.
Yes, Your Lordship. Your Lordship, as per Your Lordship, Jaggu, Your Lordship, that was the case that
Jaggu
was relied
has
upon,
been
Your Lordship.
considered by this court in another decision in the division bench.
Yes, Your Lordship.
I have considered Jaggu, the
Yes,
Tamil Nadu matter and everything. Then I have come to a conclusion.
Yes, Your Lordship.
And without a post you are working, there is Supreme Court decision on the point that you cannot be regularized. You're not working against any post.
Yes, Your Lordship. I'm working as a technical bearer, Your Lordship.
Bearer,
now.
but there is no post created for you.
Yes, Your Lordship.
There is a Supreme Court decision, latest, which says that if you're not working against a post, you're not entitled.
But Your Lordship, my now second employment was made as a bearer, Your Lordship, which was only been approved by the registrar, Your Lordship, which was with the approval of the vice chancellor, Your Lordship. If Your
No,
Lordship-
it is. In a
Yes.
university, they can't appoint anybody without an approval from the competent authority.
Yes, Your Lordship, may very well peruse Annexure 4, Your Lordship, at page number 26, Your Lordship. I was again, Your Lordship, reappointed as a bearer, Your Lordship, page number 26, Your Lordship, on a contractual basis with the approval of the vice chancellor, Your Lordship.
Okay, this will not give you any right.
And my uninterrupted services, Your Lordship, which has also
You
been certified.
continue. You did not succeed in this election. Will not.
Yes, sir. So that is not my case, Your Lordship. I have only made those statements because I have come before this honorable court with.
You
clean
don't have
hands,
any
Your Lordship.
scheme for regularization.
No, Your Lordship. They do
We
not have
give
any.
weightage, my lord. There was a
The
decision.
weightage is given in lieu of that. Clause M.
Yes, Your Lordship. I have also not disputed Your
So,
Lordship.
Mr. Decca, we are closing this.
Your Lordship may fix it after vacation, Your Lordship. I'll satisfy Your Lordship on some other points, Your Lordship.
Raised, heard Mr. D. Decca, DS Decca, Learned Counsel for the petition. Also heard Mr. P. D. Nair, Learned Senior Counsel, assisted by Mr. A. Secretary, appearing for the respondent university. Considering the issue raised in the present writ petition, admit the writ petition for hearing. Registry to list this matter for hearing in the month of September 2026.
Your Lordship, may I submit, Your Lordship? My now agreement with the university has been only till October, Your Lordship. I
Yeah,
prayed
this is
for an
not,
earlier
this is
date,
not a
Your-
prayer here. If they remove you, come back, we are here. Come back, we are here.
Your Lordship, may earlier date, Your Lordship. I'm only praying. Your
September, they will give you. D, please.
Much obliged, Your Lordship.
May the matter be passed over for time being.
Lordship, in this case, the area amount has been claimed, but there was some mistake in our proposal sent by the inspector of school. So we have director has asked us, inspector of school, to resubmit the proposal with a correct figure, Lordship.
It is submitted by Mr. P.P. Dr. Learned Counsel for the petition of Learned Standing Council, Secondary Education Department, that a proposal was already received in the matter for release of the area salaries of the petitioner for the period of his suspension. However, on account of an error occasioning in the said proposal, a fresh proposal has been directed to be submitted by the inspector of jurisdictional inspector of schools. He submits that the said proposal would be received and proposing and processed for release of the area dues of the petitioner within a further period of
After 1 month, Lordship, matter may be fixed. I will get the instruction.
within a period of 1 month from today. Registered to list this matter again on 22/7/2026. This court notices that the areas of pay of the petitioners is for the period of his suspension with effect from 5/1/2008 to 28/2/2013. The said period was regularized way back on 29/2013. The respondents shall also apprise this court on the next date of listing the reasons for the delay occasioning in sanctioning to the petitioner his due amounts. The said reasoning is to be brought on record for fixing the responsibility of payment of interest to the petitioner for the delay occasioning in releasing to him his admitted dues, as well as for fixing a responsibility on the officials who are and also for fixing responsibility on the officials who were to process the matter for expeditious release of the dues to the petition.
Obliged.
Wait, you'll get interest. What is that?
35.
This is already decided.
Yes, Lord.
None appears for the petitioner on call. Ms. H. Tarangpi, Learned Counsel, submits that the issue arising in the present writ petition is already decided by a division bench of this court in the case of Binodini Singha versus State of Assam and others, order dated 8/8/2024 in WA number 155/2022. This court has perused the said order and finds that the issue involved in the present writ petition to be covered by the said issue. However, noticing that there is no representation on behalf of the petitioners, the present writ petition, this court refrains from dismissing the present writ petition on merits. The present writ petition, however, stands dismissed on default, for non-prosecution. So, report likhima, none appears for the petitioner. Ms. H. Tarangpi appears, standing counsel.
33.
Yes. Secondary. Yes, Mr. Doctor. What has happened? Why the Nagaon district was left out?
Yes, ma'am. Madam, here, draft graduation list already published on.
No, with that,
27,
I want to know with
2024.
that.
And thereafter, one court case was instituted. And
There was a stay.
it is still pending, man.
Stay.
Here it is not mentioned regarding the stay
Then
of.
why was the Nagaon district discriminated against?
But here, my lord, as per that instruction, due to pendency of aforesaid writ petition.
Oh, mere pendency, you don't do anything. Give me that in writing that if there is a case pending in the High Court, we
Yes,
will
it
do
is
nothing.
pending.
Hmm?
Still
We
pending.
will do nothing. The other districts appointments made.
Yes.
Perhaps, Lordship, and
Then-
so far as I know, Nogao,
Nagaon
There's
is
no stay
excluded.
perhaps.
No, nothing else.
there is no stay.
Show me your instruction.
Yes.
Mr. Sharma,
Yes.
show me the legal basis of this instructions. Was there a stay order from this court?
Probably knows.
No,
the
then.
order.
Who is this director, inspector to act in this manner? And you are just giving a approval to his actions. And you want a leave now. What leave you require? Complete that process within 1 month. Come back to us. Mr. Ayush Sharma, learned counsel for the petitioner, submits that he be granted a month's time to enable the respondent authorities to take the process involved. Also for recruitment to the post of principal for the Nagaon, headmaster for the Nagaon district to its logical conclusion. Yes. It is submitted that the said process was kept in abeyance only on account of pendency of a writ petition before this court assailing the draft gradation list. Mr. Sharma, however, submits that there is no indication that a stay order was passed in the matter by the court considering this said writ petition. So accordingly, in view of the above, the registry to list this matter again on 27/7/2026, on which date Mr. Sharma shall apprise this court about the further developments taking place in the matter.
All right, Lordship.
Yes.
Lordship, we raised some issue. Lordship, can you come to page 48?
48.
This has not been complied with by the administrative department.
I find that there is some. Okay. None, there is none, none appears for the petition on call. Mr. B. Chakraborty, learned standing counsel, AG, Assam is present. For the ends of justice, registry to list this matter again after the ensuing summer vacations.
Happy, Your Lordship. Here in this matter, I have yet to receive my instructions, Lordship. I have not yet received my instructions, Lordship. It's
27/5/2026, there is a direction.
page 40.
Yes,
Police is already. provided-
27/5 we had directed you.
Yes, Lordship, I have
Why?
written also, but I have written to the department, but I am yet to
They have
receive.
not given you instructions.
No, Lordship.
Whom
So,
have you written to?
Lordship, can it be immediately after vacation,
No.
Lordship?
Police authority.
Ma'am, person has retired. Retired.
And my lord, the college principal also, my lord, forwarded the-
Only 25% you want, nothing else. No proceeding. What
No
happened to the criminal case?
email case is my lord pending, my lord.
Charge sheet?
Charge sheet, my lord, trial.
Charge sheet it?
Yes, lord.
When?
Malad, that instruction I have to receive. That instruction I have to receive also. There is Malad, tile is going.
Huh?
Tile is
No, no,
going.
when was it charge sheeted?
Charge sheet and Malad, I have to take instruction.
Before your retirement or after your retirement?
Before, madam.
Before.
Before, madam. In fact, Malad, page number 30 is Malad very clear. So while I was in service, Malad, third paragraph Malad very clear.
Two o'clock. 2 o'clock.
Here I have received the instruction, madam. Here his period has been regularized with withdrawal of one increment benefit.
The petitioner was reinstated, my lord, as per order of this honorable court. And he has not received the salary, my lord, for the period from 30/10/2025 onwards. Lord.
Now, this proposal will come from, not from the education department, elementary
No,
education
no, no,
department.
it will come from.
Come from us.
No, no, madam.
Huh? Then what is this? stand
Regarding
you are taking?
area salary, only that part, madam, we have.
What is the stand you are taking? 15 days release the area service. 15 days. We are providing for that. What happened to the departmental proceedings against you?
Just closed, man.
Huh?
Closed, man.
Closed. When? $37 is the show cause.
Yes, my lord.
When was it closed?
My lord, I have instruction from the petitioner. My lord. He informed over telephone that it is closed.
When was
So,
it
my lord,
closed, madam?
document, my lord.
You will have to give me that.
Yes, my lord. I'll find additional affidavit, my lord.
However you do, bring it on the prayer of the learned counsel for the petitioner, register it to list this matter again after the ensuing vacations. The petitioner to apprise this court on the next date of listing with regard to the fate of the departmental proceedings instituted against the petitioner while issuance of a show cause notice dated 30/7/2024. Madam, bring it on record because that will have a bearing.
Yes, ma'am.
And if that proceeding is complete, do it before the next date. Give her whatever whatever he gets.
I will ask the report.
Iman?
May I please, Lordship? Lordship, this matter is regarding pensionary benefits, Lordship. I am the mother of my deceased son. My deceased son first wife expired. Again, he remarried. And
Yes. Why is the mother not given anything? Not being maintained?
No, already paying.
Where? Where? Show me. How much are you paying? What is this? I don't understand. What is this? Oh, 1 lakh rupees, maybe that pension, but monthly pension, how much are you giving her? Mother, she was under she was being maintained by her son. How much are you giving her from monthly pension? Done. You will not get 100%.
yes, yes, Lordship.
Whatever they give you, take it. Get how much you are going to pay to her, your mother. It's your duty to take care of her. If you are not taking care, we will stop your pension also. Right? At 2 p.m., come and tell me that we will give this much amount, percentage. Madam, come back at 2.
Obliged, Lordship.
None appears for the petitioner or for the ends of justice. Raise it to list this matter. Not time being prepared. After the, as agreed to by the learned council for the parties, register to list those matters again after the ensuing summer vacations.
Diplom.
Who is there for the, you have created a mess. Do you know what you have done? How the college, who is for the college? Who is for the college, Mr. Day? Mukhtar, SK Mukhtar.
Mukhtar.
Now, 2 posts were advertised for unreserved. Roster point 16 and 18. They have held 2 selections. One for roster point 16, another for roster point 18. How can you do that?
Regarding his post, my lord, the petitioner, under roster, his roster upon already one.
I got it, but where is this contemplation of a selection? Who are the roster point? Unreserved should have been earlier. Now, if we amalgamate both these elections, he is number 1. So he gets in. Hirak Jyoti, the second one, will have to be, you make him a party, mold your prayer.
What? I have
You make him party, otherwise we can't help you.
I have
Mr. Day, have you understood? There are 2 selections held. This, if we amalgamate, then Medhi will go. Make him a party. Or you don't want to?
But actually, my lord, still they have not appointed it.
Who?
Authority.
Medhi not appointed?
Not appointed. Not appointed it.
No, one post subsequently fell vacant.
And
That
moreover,
will
one
go
post
for
is.
That cannot be brought here. That is different.
Lordship.
Now this Medhi, Medhi or whatever his name is,
Hirak Jyoti.
not appointed.
Not appointed.
How do I get that?
Because I have a instruction, Lordship, in the RTI reply also. Even on the last occasion, Mr. Mukhtar also submitted before this court, still that he has not been.
Can you get Mr. Mukhtar?
Okay, Lordship.
Then we can mold this thing.
I have a instruction, Lordship.
Now Mr. Mukhtar is here.
Yes.
Mr. Mukhtar, what is the selection you have done? For roster point base, you do selection. From where have you got this law?
In fact, I have been informed by colleagues that the director has verbally instructed them to hold like this, my lord.
Verbally.
This is the
Who
information.
was
I
the
have.
director who gave that instruction?
To hold the separate.
Against roster point, unreserved, I understood. 2 together. Now, if we amalgamate that selection, then petitioner is serial number 1.
His number is higher, my lord.
Higher, 72.
He should
And
get, my lord. We are.
what about Hirak Jyoti? Hirak Jyoti Medhi.
My lord, he was selected in for 16, number 16 point, but his number is less than him, my lord.
No, he is working.
No.
Hirak Jyoti?
I think he has been appointed, my lord, by the director.
No, Lordship. So far, the RTI reply is there, still it is vacant. It's not been given appointment.
Post is vacant, my lord. There is
Yes.
post vacant, my lord.
Where?
No, one.
In college, that roster point number 1 for unreserved is still vacant, my lord.
No, that is a subsequent vacancy.
Subsequent vacancy.
That cannot be brought.
That is of course, my lord.
That cannot be brought.
That of
That
course,
we will not permit.
Now, let them to provide Mr. Hirak Jyoti there only. We have no objection.
No. First you bring Hirak Jyoti
Lord.
in this proceeding.
But he has not been appointed, Lordship.
Oh, bring it. File an additional affidavit to that effect. Also, implead him as party respondent. You file it within this week, we'll allow.
Today, they should have to produce an instruction.
You forget that. If I have to touch, give you any relief, I'll have to touch.
Lordship.
I can't touch him without hearing.
Lordship.
You make him a party.
Lordship.
On the prayer of Mr. DK, Learned Counsel for the petitioner, register to list this matter again on again after the ensuing summer vacations. You file it, make a mention, get it.
Lordship, my humble submission, kindly date may be fixed, Lordship.
No, you file that IA.
File. In the meantime, I will file.
You file it, make a mention, it will come. Immediately we'll do it.
Lordship. Oblige.
And Mr. Mukhtar, if your college is proceeding in this direction, ask them not to do that.
Of course, I have said that this is
Unreserved,
incorrect.
unreserved, I can understand. Unreserved, one selection should be there,
Yes,
but okay. Unreserved, you hold it separately. Reserved, you hold it separately. Fine, I understood.
This is the incorrect
But
one. In my numbers, I have
Rooster
told them.
point wise,
I have
Because
spoken to
the
the
planning
authorities. I have spoken to the authority. What they said that selection was held in a single selection, but the recommendation was changed against one post, one recommended candidate, my lord. That's
no,
why.
there were
that's
two selections. Two selections were held.
Two selection.
Rooster point.
The same day, man. He's saying same day.
Same
but
day.
For 16, one selection board. For 18, one selection board.
How can that be? But same members.
Same members.
Members may be same, man.
Members, name member.
Everything is same, even adjustment.
The respondents shall also apprise this court as to whether there was one selection held for the post of post of LDA,
Grade 4.
grade 4, unreserved against rooster point number 16 and 18, and thereafter two separate recommendations were made. Thereafter, separate select lists were prepared prepared for each of the rooster points involved. Give me that. That if it comes also, Mr. He may be true.
We are sympathetic for him. He should get back.
But the technicality now has to be taken care of.
Obliged, Lordship.
Yes.
My lord, in respect of WBC number 707.
Forget that. What about the WPC
Lordship,
IA
my
2044?
lord, they filed an impeachment petition. I specific challenge regarding challenging the promotion to respondent number 6, lordship. Neither made the governing party nor made the chairman of the selection committee. I specific objection against this. They filed an impeachment petition required to file rejoin against affidavit lordships. And my case they also filed. I also challenge the promotion of the read petitioner of 2237. He filed an affidavit lordships. A rejoinder is required lordships.
No, what about this IA?
IA is regarding impeachment.
2044.
IA is regarding impeachment.
Oh, we'll allow this.
Lordships, no, I have to file an objection.
Why? You, that is
I
what you
specific-
pointed out, that he has not filed it. Now he has filed it. Why should
Lord,
we?
Now he want to fill up the
Whoa,
lacuna,
whoa,
lordship,
no,
but-
it is permissible.
But
It is permissible.
Certainly permissible, but
It is permissible under law. Show me a law that it cannot be done.
okay,
Then-
that can be lord, that power. But next case is rejoinder is required, lordship.
But the next case, I forget. Now I am only with the IA. We are allowing the IA with your
Like,
consent.
Leave it to your lordship, but my objection will be
No,
recorded.
no objections can be. You had raised this point.
Yes,
Lekha. Heard Mr.
N. Gogoi.
N. Gogoi, Learned Counsel for the petitioner. Also heard Mr. F. Barbhia. U. Barbhia, Learned.
respond number 6.
No. Who is appearing for Karbi Anglong? Name? Huh? So and so Learned Counsel appears for the respond number 1, 2, 3. 1, 2, and 3, madam. Mr. Who is appearing for 4? Mr. U. Goswami, UK Goswami, Learned Counsel for the respond number 4. Mr. S. Bhuya, Learned Counsel represents respond number 5, while Mr. F.U. Barbhia, Learned Counsel represents opposite party number 6. The present interlocutory application has been instituted by the petitioner, praying for impleading the president of the governing body as well as the chairman of the Departmental Promotion Committee as party respondents in the connected writ petition being WPC number 2237/2025. Also, it is seen that the writ petition was so instituted assailing the selection of the respondent number 6 as head assistant in Diffu Government College Such selection is found to have been so made by the Departmental Promotion Committee and thereafter on approval of such recommendations made by the Departmental Promotion Committee, the respondent number 6 by the governing body of the college, the respondent number 6 was so promoted as head
Only
assistant,
recommended, Lordship.
recommended for appointment, no?
appointment.
For appointment as head assistant.
Head assistant.
So, in view of the above position, the applicant has further submitted that inadvertently the president of the governing body as well as the chairman of the departmental promotion committee of the college was not implemented as were not arrayed as respondents in the connected writ petition, and accordingly the present interlocutory application has been filed. I have had the learned counsel for the parties and also perused the materials available on record. This court finds that on so on considering the contentions raised in the interlocutory application and also appreciating the submissions made by the learned counsel for the parties, this court finds that the parties sought to be implemented in the connected writ petition as respondents are necessary and proper parties to the said proceeding and would facilitate a proper and due adjudication of the issues arising therein. Accordingly, the applicant is permitted to Roman 1 and Roman 2 Kuribide, A to A, page 3. So and so as party respondents as party respondents number
8 and
8
9.
and
8 and 9 in WPC number 2237/2025. Also, with the above observations and directions, the present interlocutory application stands disposed of. 2237 WPC. In view of the order passed today in I bracketed C number 2044/2026, the petition impleading the following parties as following parties, A1, 2, Kurdivi, as respondents number 8 and 9 in the present writ petition, petitioner to file a amended cost title within 2 working days. On filing of such amended cost title, the petitioner to take steps for service of notice upon the newly implemented respondents number 8 and 9 by way of speed post steps within 3 working days from today. Registry to list this matter along with WPC number 7072/2025 after 4 weeks on a date to be fixed.
Obliged.
In this
First
case,
order.
already one speaking order has been passed, just now I have received, so. And that may be taken day after tomorrow, I have to go through this order,
Have you given him a copy?
Yes, ma'am.
Miss. Earlier order withdrawn.
Yes, ma'am.
Miss N. Fukan, Learned Counsel for the petitioner, for the Learned Standing Council Elementary Education Department has placed on record an order date 26/2026 passed by the Director Elementary Education Officer by cancelling the earlier order dated 19/11/2024. Also, a copy of the said order be furnished to Mr. F.U. Borbian. Also, registry to list this matter again on 23/7/2026 for admissions. Also, you go through it, then we'll see. A copy of the order dated 26/20/26 furnished by Ms. N. Fukan is kept on record and marked as X for the purpose of it.
Deeply obliged.
Obliged.
Okay, Noelis, pick up again the dictation in the order. All right, so much.
My lord, in this case, we have prepared one affidavit. It was sent for vetting, but it has not come back yet, my lord.
But Mr. B. Purkhaistal and a counsel for the petition.
There are some urgencies there on my.
No, Mr. B. also heard Ms. P.
My
Chakraborty, Learned Standing Counsel, Social Justice and Empowerment Department.
May I pray for a longer date? Here, there's some difficulty as their government is yet to take a decision. There is a regarding change of rules of the erstwhile social welfare
got-
department.
Ms. Chakraborty submits that she be granted time till 31/7/2026 to file her affidavit in the matter. Pray accepted. Beyond that, we are not going to use. Registry to list this matter again on 5/8/2026. No further time shall be granted to the respondents to file an affidavit. No grievance, no?
My case is on covered case number. I have also annexed the judgment also.
The interlocutory IAD. The present interlocutory application has been instituted. I heard Mr. S.B. Loskar. Present interlocutory application has been instituted, praying for, impleading the SCRT. SCRT authorities as party respondent in the connected writ petition being WPC number 1120/2026. Also, considering the nature of the issue raised in the connected writ petition, this court is of the considered view that the State Council of Educational Research and Training, bracketed SCRT, is a necessary and proper party in the connected writ petition. Accordingly, petitioner is permitted to implead the State Council, implead the following party, following authority as a respondent in the connected writ petition. Apostrophe bitter. State Council of Educational Research and Training, SCRT, represented by its director, Assam SCRT Assam, represented by its director, Kahili Para Gauhati -781019. Huh? So, with the above, so and so party respondent number, over 9, what would be 7?
7.
Party respondent number 7. So, in view of the above, with the above observations and directions, the present interlocutory application stands disposed. It's not the director. You make SCRT represented by the director. I've corrected it here. And in view of the order passed today in IAC number so and so, permitting the petitioner to implement so and so as party respond number 7. Paki? Steps steps within 2 weeks. After 4 weeks listing.
Motion.
Yeah, act number. What is that? We'll pass the orders.
Yes, Pastor. Yes.
But we are going against.
Yes.
You are not claiming under 1972. You are claiming under this act. You are claiming under the regulations.
Regulations.
Lekha. Heard Mr. A. Sharma, Learned Counsel for the petitioner. Also heard Mr. S. Doctor, Learned Senior Counsel, assisted by Ms. S. Musahari. She was the Learned Counsel for the respondent bank. Also, the present matter was heard at length on 27/5/2026 and was directed to be listed today for delivery of orders. Also, the petitioner in the present writ petition, we are only concerned with gratuity. Others things I think you have got.
No, the others we have not got. Also regarding leave encashment
Hmm.
and
Leave encashment, GSLI, pension,
yes, leave
gratuity,
encashment, GSLI, we have not got. Pension we are getting
pension you are getting.
because of 2018.
Leave encashment also not got because of this bar.
Yes, leave encashment and GSLI.
But no material, no submissions that you are entitled to leave encashment. You are only confined to gratuity.
In the prayer portion, we have written that these
Only
are
that
the
much, but there is no material.
otherwise no.
We'll only concern to gratuity. Other things, if you
Leave
are
those
there,
options.
huh?
Leave those. I mean,
that you approach. We'll
we keep it open.
I'll keep it open. Heard Mr. Also so and so. The petitioner, by way of instituting the present writ petition, has primarily prayed for a direction upon the respondent bank to release to him his gratuity on being released from his service after being imposed with the penalty of compulsory retirement via an order dated 23/12. Have your seats. 23/12/2015. Also, as projected in the writ petition, the petitioner, in pursuance to a departmental proceeding instituted against him, was via an order dated 23/12/2015, imposed with the penalty of compulsory retirement. Also, the petitioner, on being placed under compulsory or on being discharged from his services, on being imposed with the penalty of compulsory retirement, had approached the respondent authorities for release to him his pension and other pensionary benefits, including gratuity. Also, they said benefits not having been released to the petitioner, he has instituted the present writ petition. Mr. A. Sharma, learned counsel for the petitioner, has at the outset submitted that the petitioner in the present proceeding has not presented a challenge to the penalty of compulsory retirement as imposed upon him. It is submitted that the petitioner is claiming the benefits, service benefits, which he is entitled to receive even after being imposed with the penalty of compulsory retirement. Mr. Sharma submits that the petitioner is entitled to receive his gratuity along with other retirement benefits like leave encashment, GSLI, pension, etc. It is submitted that the petitioner is in receipt of pension. Accordingly, the said prayer is not pressed in the present writ petition. Mr. Sharma has fairly submitted that with regard to the prayer for release of leave encashment and GSLI, no material has been brought on record in the present writ petition by the petitioner. Accordingly, he prays that with regard to the said two benefits receivable by the petitioner be permitted to approach the respondent authorities by way of filing an application seeking release of the said benefits to the petitioner. Mr. Sharma submits that the present writ petition would be confined to the claim made by the petitioner for being released his gratuity on being discharged from his services upon being imposed with the penalty of compulsory retirement. Mr. Sharma submits that the provision for release of gratuity is found in the provisions of section of regulation 72 of the Assam Gramin Vikas Bank officers and employees service regulation 2010. He submits that every officer or employee shall be eligible for gratuity on termination of his service in any other way except by way of punishment after completion of 10 years of service. He further submits that proviso to section 72 bracketed proviso to sub-regulation 2 of Regulation 72 further provides that in respect of an employee, there shall be no forfeiture of gratuity for dismissal on account of misconduct, except in cases where such misconduct causes financial loss to the bank, and in that case, to that extent only. He submits that the release of gratuity being a beneficial financial benefit extended to the retiree, the said benefit would also be mandated to be released to the petitioner herein, inasmuch as it has not been, inasmuch as the loss occasioning to the bank on account of the misconduct established against the petitioner has not been quantified. Accordingly, he submits that the benefit as extended to an employee in the branch would also be required to be so extended to the petitioner who is otherwise an officer in the bank. In support of his submissions, Mr. Sharma has relied upon the decision of the Honorable Supreme Court in the case of Shyamlal versus State of Uttar Pradesh, reported in 1954 1 SCC 572. Mr. Sharma has also relied upon the decision of this court, of a coordinate bench of this court, also relied on the following. Has relied on a decision of a coordinate bench of this court in the case of Boloram Bodloy versus Lokimi Gauhati Bank, order dated. What is the judgment and order? Date. Judgment and order dated so and so in
3/4
WPC number
3/4/2009 was the order.
3/4/2009.
High Court
WPC
order.
number 219/2006, which is contended to have been upheld by the division bench in WA number 361/2008 and by the Honorable Supreme Court in the case of, in civil appeal number 4394/2010, right?
Yes, Lordship.
Oh, so.
On 8th of February 2021.
Now that. Oh, so. Mr. Sharma has accordingly submitted that following the law laid down by the Honorable Supreme Court in the case of Shyamla, the compulsory retirement cannot be held to have the effect of a dismissal and or removal being effected on the petitioner, and accordingly he would be entitled to receive his pension and his gratuity along with other pensionary benefits. Also, per contra, Mr. S. Dr. Learned Counsel for the respondent bank, by referring to the provisions of, by referring to the Assam Gramin Vikas Bank bracket officers and employees service bracket service regulations 2010 has submitted that the term employee and officer has been so incorporated in the regulations with distinct meanings, with distinct definitions. The definitions have been set out for the term employee and officer in the provisions of sub-regulation, in the provisions of Regulation 2. He submits that while an officer or an employee would be entitled to receive gratuity under the provisions of section sub-regulation 2 of Regulation 72, in so far as it concerns an officer, on account in the event a termination of his services occasioned by way of imposition of a penalty, such officer would not be entitled to receive a gratuity. He submits that the proviso to sub-regulation 2 of regulation 72 is only in respect of an employee and cannot and is not attracted in respect of a officer. Mr. Mr. Dr. Learned Senior Counsel further submits that the petitioner in the present proceeding is not claiming his gratuity under the provisions of the Payment of Gratuity Act 1972, but is so claiming the sometimes like this, and it's good. It gives a change in the perspective. But it should have come a little bit later. Anyway, but he is claiming the said benefit under the provisions of sub-regulation 2 of regulation 72 of the Act.
And also the pension rules 2018 proviso 44. That was what we was argued, Lordship.
Where?
That Assam Gramin Vikas Bank employees pension regulation 2018, wherein I had made two arguments. One was that here the distinction between an officer and an employee has been taken away. Here employee would mean anyone. That J definition of employee, there is no definition for officer. And then if I take your losses to 44, regulation 44, which speaks about gratuity. The definition, employee, and internal page 60, regulation 44. 44 2 deals with gratuity. It speaks about a disciplinary proceeding, it speaks about recovery, and then it speaks about gratuity. 44 2. That will be applicable to an officer also under these regulations. This was my second line of argument.
Mr. A. Sharma has, by referring to the provisions of Assam Gramin Vikas Bank, bracket employees, pension, bracket over, employees, pension, regulation 2018, more particularly regulation 44 thereof has submitted that the said regulation with regard to release of provisional pension has not made any distinction between an employee and an officer. He submits that the term used employee, the term employee used in sub-regulation 1 of regulation 44 is used in a general term to describe all persons working in the bank, all persons in the service of the bank.
And 44.2 refers to gratuity.
Coming.
Yes, yes.
He further submits that sub-regulation 2 of regulation 44
refers to gratuity.
in respect of the persons covered by sub-regulation 1, gratuity shall be paid to them only on conclusion of proceedings, and any recoveries to be made from an employee shall be adjusted against the amount of gratuity payable. Accordingly, he submits that the term employee as finding mentioned in the proviso to sub-regulation 2 of regulation 72 would have to be read in connivance with the would have to be read together with the provisions of sub-regulation 4 of regulation 44, and accordingly the term employee has to be given a wider meaning than that sought to be given by the bank authorities, right?
Yes, Your Lordship.
Mr. Dr. submitted that it was a pension under this provision. Accordingly, he submits that it is the provisions of the present of the regulations of 2010 that would hold the field. He submits that sub-regulation 2 of regulation 72 having barred the release of gratuity to officers who have been terminated from their service on account of imposition of a penalty, comma, the petitioner herein having been terminated from his services after being imposed with a penalty which of compulsory retirement, which admittedly had brought about a cessation in the employer relationship existing between the petitioner and the bank, comma, the bar under sub-regulation 2 of regulation 72 would stand attracted in respect of the petitioner herein. In support of such submission, the petitioner, Mr. Datta, has relied upon the decision of the division bench of this court in the case of order dated to Nayate Ulailba, WA number 59/2015. Suman order, Suman. Mr. Datta has further relied upon the decision of the Honorable Supreme Court in the case of P. Rajan Sandhi versus Union of India and others, reported in 2010 10 SCC 338. With regard to the submission made by the Learned Counsel for the petitioner by referring to the provisions of section regulation 44 of the pension regulations of 2018 of the bank, Mr. Datta has submitted that the term employ as finding mentioned therein cannot be given a different meaning than the meaning given to the term employ in the regulations of 2010. He submits that where there is no, he submits that although the term officer has not been defined in the pension regulations of 2008, comma, sub-regulation 2 of regulation 2 of the 2 bracket 20, but a sub-regulation of the pension regulations 2018 mandate that all other words and expressions used in this regulation but not defined and defined in the Act or the Assam Gramin Vikas Bank bracket officers and employees service regulation 2010 shall have the same meanings respectively assigned to them in the Act or as the case may be in the regulations of 2010. You got that point? That is why I did not put that in first. Accordingly, he submits that the claim of the petitioner for Mr. Datta further submits that the reliance placed by the petitioner on the decision of Shyamlal as well as in the cases instituted by Bolaram Bordele, comma, would not advance the case of the petitioner inasmuch as in the case of Shyamlal, the penalty, the compulsory retirement as imposed upon the appellant therein was not as by way of a penalty, but was on account of the fact that the appellant therein was found to be not suitable for continuity in service after completion of 25 years. So I've heard the Learned Counsel for the parties and also peruse the materials available on record. The facts in the matter are not in dispute. The petitioner, on being imposed with a penalty of compulsory retirement upon conclusion of a departmental proceedings instituted against him, comma, stood terminated from his services. Such termination, the penalty, not disputed. The petitioner, on being imposed with the penalty of compulsory retirement from his services, comma, a cessation of the employer relationship occasioned in the matter between the petitioner and the respondent number 1 bank. The petitioner on an employee of the bank, a member of the bank either a member of the either an employee and or a officer of the bank, comma, is entitled to receive on such on their retirement from service gratuity as provided for under the provisions of sub-regulation 2 of regulation 2 or regulation 72 or under the provisions of the Payment of Gratuity Act 1972. It is not disputed in the present petition, in the present proceedings, that the petitioner's claim for gratuity is the one that is provided under the provisions of the regulations of 2010 and not what is so provided under the provisions of the Gratuity Act of 1972.
May I just interfere? The definition of employee includes the word officer. I was just reading it.
Okay.
The definition of employee in the regulations
Hmm.
include the word officer
Of
of the bank.
which regulation?
2018 regulation. The definition of employee, because Lordship will refer to that proviso that last it has not been included.
I'll do.
Officer word is here.
Where is that officer word?
They.
Employee
Definition
means
they.
any person employed in the service of the bank, whether as a workman on full-time basis, part-time basis, or as an officer.
Or as an officer.
Okay.
I'll be failing my duty if I don't point
No,
this
no,
out.
please, you have done the right.
That officer word is there. So it has been
Okay.
defined. Officer is also an employee. So therefore 44.2 probably will be applicable.
I'll do that. So, would be, but you would have no doubt that you are covered by the graduation regulation of this bank for gratuity, not the Payment of Gratuity Act.
I was applying under this.
This only, that's it. Likha.
Because I have not proceeded under the.
No, you cannot,
provisions
because
of the
you are getting a
Gratuity Act.
better benefit here. Because there it will be only 15 days. You are getting that 30 plus thing also here.
Yes, yes.
Ki
Now
likha?
I cannot change the stand mid course.
Also, in view of the above position, accordingly, the petitioner's claim for gratuity has to be strictly construed in terms of the provisions of section 72 of the regulations of 2010. The provisions of regulation 72 bracketed 1 and 2 being relevant is extracted here in below. A to A. A perusal of the provisions of subregulation 2 would reveal that every officer or employee shall be eligible for gratuity on retirement, death, disablement, rendering him unfit for service, further service as certified by a medical officer approved by the bank, or resignation after completion of 10 years of continuous service, or termination of service in any other way except by way of punishment after completion of 10 years of service. So, the petitioner's termination of services having occasion on account of the imposition of penalty of compulsory retirement upon the petitioner, comma, the petitioner in terms of the provisions of 72 bracketed 2 bracketed E of the regulations of 2010 would not be entitled to be released a gratuity under the provisions of the regulations of 2010. So, however, the petitioner has, by referring to the proviso to subregulation 2 of regulation 72, projected that in the set aspect projected that the set proviso on being construed in the light of the provisions of regulation 44 bracketed 2 of the pension regulations of 2018, comma, even an officer would be entitled to be released a pension. So,
Gratuity.
gratuity. a perusal of the proviso to sub-regulation 2 of regulation 72 would go to reveal that the same is only applicable in case of an employee of the bank, not in respect of a officer. Accordingly, this court is of the considered view that the proviso to regulation 72 bracketed 2 of the regulations of 2010 would not advance the case of the petitioner herein. Having drawn the said conclusion, this court would now examine the contention raised by the petitioner with regard to regulation 44 of the pension regulations of the 2018. The provisions of regulation 44 being relevant, is extracted herein below. B to B. Page 8. Maras. Wrong. So, a perusal of subregulation 1 of regulation 44 would go to reveal that the same is applicable in case of an employee against whom a departmental or judicial proceeding instituted is pending finalization. So, subregulation 2 of regulation 44 is only applicable in respect of payment of gratuity in cases of an employee involved in the situation covered by subregulation 1 of regulation 44. It is in respect of such employee that a clarification has been provided that the gratuity shall be paid to the employee and only on conclusion of the proceedings, and any recoveries to be made from an employee shall be adjusted against the amount of gratuity payable. The said provision cannot be held to have the effect of overriding the provisions of the regulations of 2010. So, the heading of the regulations of 44 of the pension regulations of so and so of 2018 also is a provisional pension, not final pension. Accordingly, the said provision is akin to the provisions of section rule 22 of the Assam pension, Assam Services Pension Rules 1969, which is also a provision of interlocutory interim application during the pendency of a departmental and or a disciplinary proceeding. Accordingly, this court would accordingly the contention of the learned counsel for the petitioner, cleverly made stands rejected. That's the beauty of Mr. Sharma. Also, in view of the above position, subject to the liberty, in view of the above conclusions, subject to the liberty granted to the petitioner to approach the respondent authorities by way of filing an application for release of his leave encashment of the GLSI benefits, the present petition stands dismissed. I'll incorporate something more.
Yes, Your Lordship.
Yes.
Obliged.
Come back at 2.
Yes. Okay, item 49 and 51, these two consent matters. Lordship, may I take it after vacation, Lordship? And these for other side, Lordship. SLC has already, it was placed before the SLC, it was sent to the government for its appropriate instruction, Lordship.
49?
49 and 51. same matter, Lordship.
You were supposed to produce the orders today.
Last
Orders
month.
in compliance, yes.
Yes, it was placed before the excellency. It was sent to the government for its approval, Lordship.
Government is also you only.
Yes.
What happened to the government? That was done earlier. Last date, SLC had already cleared.
Yes.
It had gone to the government. What happened from the government?
Government from that, government sought some time because it was placed before the legislature. Because the year of, that 2017 was.
We have clarified that in our orders. I think
Yes.
it was my order.
Yes, yes, yes.
We have clarified
It
that.
will be implemented, Lordship, only.
You have said it will be implemented, but that implementation is not occasioning from 24. 2
Yes,
months time
yes,
was
yes.
given.
Yeah.
So Mr. Chisti says, give me a date on that day, but I want the compliance order and I'll record it in that manner. You have it, ask somebody to give a date. You need not come if you are busy.
I have to come, Lordship, like another order is there.
Then you give me a date by which you will comply. We will fix that matter on that day. Disposal. Anything more?
No, no. Will be taken up.
Mr. Swekia, what are you waiting for?
Second of no?
The contempt case is pending for last 7 years.
Which one?
The part, item number 47. But service is not completed yet, my lord. No, service, my lord, responder 7 is name may be related. He is a headmaster, he retired. It is duty of the director and commissioner. They can compare the order to hold in there.
Yes, Mr. Chisti. What has happened to this? Yes, it's true. This is pending from 2020. Order is of 2018.
My lord.
A selection process was directed to be initiated.
Yes, that was the simple matter. Service to the director also not completed here. He can appear, my friend can appear for the director.
I'll get the answer.
Mr. Swekia, if you're not here, no problem. Ask your junior to be here. We'll pass appropriate order.
My lord. Only my prayer, let
We'll
them
see.
hold the interview.
We will see.
Nothing
We'll
more,
see.
my lord,
We'll
because
see.
the ball is evolving.
We'll see. Mr. Chisti has taken it up.
World Cup is going on.
No, Mr. Chisti has taken it up. He will get off.
Ball is running from this place to that pole.
Oh, give him some time.
My lord. You lordship can interfere.
We will do the.
My lord. Then let
But Mr. A.K. Borua.
Yes.
Borua, Learned Counsel for Election.
Lordship. Petitioner has not,
Huh?
petitioner has not received the area subsistence allowances, leap encashment and GIS MLR.
Also heard Miss M. Kotoki, Learned Standing Counsel, Animal Husbandry and Veterinary Department, appearing for the respondents number 1, 2, 3, 1, 2, and 3. So further. Also heard Mr. R.K. Talukdar, Learned Standing Counsel, Accountant General, bracketed ANU, that is the respond number 4. Also, Mr. K. Fukun, Learned Government Advocate, Assam, appears for respond number 5 and 6. Also, have your seats. The petitioner in the present writ petition has prayed for a direction upon the respondent authorities to authorize to him his regular pension as well as his other pensionary benefits, including gratuity, leave encashment, GIS, etc. So, the facts in brief requisite for adjudication of the issues arising in the present writ petition is noticed as under. So, the petitioner, while working as a subdivisional animal husbandry and veterinary officer came to be placed under arrest on 23/11/2021, in connection with Kokrajhar Police Station case number 817/2011-21. Also, on the detention of the petitioner in connection with the said criminal case, and he having remained under detention for more than 48 hours, the petitioner was wide order dated 26/11/2021, placed under suspension by invoking the provisions of Rule 6(2) of the Assam Services Discipline and Appeal Rules 1964. Also, the petitioner was thereafter released by the learned trial court on bail, was thereafter enlarged on bail by the learned trial court wide order dated 29/12/2021. Also, the petitioner was thereafter issued with a show cause notice dated 12/1/2022, instituting against him a departmental proceedings. Also, the petitioner has a petitioner on 24/1/2022 submitted his show cause reply also. Also, the petitioner thereafter, during the pendency of the said departmental proceedings instituted against him, retired from his services on 31/12/2022. Also, as the subsistence allowance for the petitioner with effect from 26/11/21 with till 31/12/2022, as well as non-finalization of his pension and pensionary benefits, the petitioner has instituted the present writ petition. Mr. A.K. Borua, learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that when was you given the provisional pension? Was authorized a provisional pension in pursuance to the directions passed by this court wide order dated 13/3/2023 in the present proceedings. Also, Mr. Borua has submitted that the petitioner retired from his services on reaching the age of superannuation, he is entitled to be authorized his pension and pensionary benefits. Also, Mr. Borua submits that the respondent authorities, without passing an order passing any order, any direction. They submits that the respondent authorities, comma, have not authorized to him his due pension and pensionary benefits. By referring to the provisions of Rule 21 of the Assam Services bracket pension rules 1969 bracket hereinafter referred to as the rules of 1969, Mr. Borua submits that the power to withhold pension is provided for in the provisions of Rule 21 of the said rules. He submits that the said power is reserved to the governor and the power is permissible to be so exercised only in the event in a departmental or judicial proceeding initiated against the retired government servant, he is found guilty of commission of misconduct or negligence during his period of service, including service rendered upon reinstatement after retirement. Mr. Borua submits that against the petitioner, no such finding having been recorded in any departmental and or judicial proceeding. As on the date of his superannuation, the provisions of Rule 21 was not permissible to be so invoked. Also, he submits that even in the criminal proceedings instituted against the petitioner, the same is pending at the stage of investigation. So, as regards the departmental proceedings instituted against the petitioner, while the show cause notice dated 12/1/2022, it is submitted that the said proceedings have also not been taken to its logical conclusion. Accordingly, he submits that the withholding of the petitioner's pension and pensionary benefits has been so done in clear violation of the provisions of Rule 21 of the rules of 1969. Also, Mr. Borua, in support of his submissions, has relied upon the following decisions. A to D. A to A. A to A to A to A to. Of the Honorable Supreme Court, decisions of the Honorable Supreme Court, and also of this court. Also, Mr. Borua has further submitted that the entitlement to pension and pensionary benefits in respect of a retired government servant is to be so ascertained as on the date of his superannuation. As on the date of his superannuation, the petitioner not being found guilty either in a departmental and or a criminal proceeding instituted against him, there was no occasion for invocation of the powers under Rule 21 of the rules of 1969, and accordingly, the pension and pensionary benefits of the petitioner would not be permissible to be so withheld. He submits that the authorization of the pension and pensionary benefits to the petitioner, however, would be subject to future good conduct, which would be the outcome of the departmental as well as criminal proceedings instituted against the petitioner. Also, Mr. Borua has further submitted that although Rule 22 is to operate in the interregnum during the pendency of a departmental proceeding and or criminal proceeding, judicial proceeding against a retired employee, Mr. Borua submits that given the intent behind grant of pension and pensionary benefits, it would be the provisions of Rule 21 that would have an overriding effect over the provisions of Rule 22. Also, episode here, para 7, a decision, judgment and order dated 3978/2023. Huh? Para 7. Ms. M. Kotoki, learned counsel for the petition, submits that admittedly against the petitioner, the proceedings submits that against the petitioners, a departmental proceeding having been instituted on 12/1/2022, the same having not been concluded, the same is now being continued under the provisions of Rule 21 of the Rules of 1969. She submits that in view of the express language used in the provisions of Rule 22 of the Rules of 1969, a government employee covered under the provisions of the Rules of 1969 would not be entitled to be granted final pension, regular pension, as well as a gratuity till conclusion of such proceeding. She submits that the petitioner is entitled only to a provisional pension and is not entitled to a gratuity till the conclusion of the proceedings instituted against him and passing of final orders thereon. I have heard the learned counsel for the parties. Facts noticed herein above are not in dispute. Petitioner was placed under arrest on (23/11/2021). So, in pursuant to his such arrest, the petitioner was placed under suspension by wide issuance of an order dated 26/11/2021 by invoking the provisions of Rule 6(2) of the Rules of 1969. Bishop A to A. Page 7. Para 10 of A to A. 8 judgment to no? Para 11. Para 12. Para 13, 14, 15. So, having drawn the said conclusion, this court would now examine the decisions relied upon by the petitioner. This court has meticulously perused each of the decisions so relied upon. So, para 16. Itu full stop for para go every Para 17. So, the other decisions relied upon by the petitioner has also been perused by this court. On a close perusal of the said decisions relied upon by the petitioner, this court finds that therein neither the provisions of Rule 22 was not attracted, and if so attracted, the Rule 922 of the Rules of 1969 was not attracted, and if so attracted, the same was not considered. Accordingly, this court is of the considered view that the said decisions would not advance the case of the petitioner hearing. So itu agot je likhisilu, this court has perused the decisions. Itu kati de direct ইয়াৰ পৰা para 16, 17 to উঠাই দিবি। তাৰ পিছত হেতু লিখিবি paragraph। ঠিক আছে? Also, a para 18. 18 or last stop. 7, sorry, para 18 or last. 19. Para 18 or last stop লগাই দিবি। No, 18 or last stop এটা line লগাই দে। The subsistence allowances of the petitioner in arrears as on date be released to the petitioner within a period of 1 month from the date of receipt of a certified copy of this order. Aki, with the above observations and directions, the present petition stands disposed of. Yeah, Roman. A list to
Obliged.
It's, I should not be giving any advice, but ask Mr. Borua to seriously think of challenging the show cause notice. I don't think that show cause notice will survive. And then let him rely upon the decision of my Lord Justice Suman Shah, which is being quoted here. I think he will get his relief. Ask him. Because that show cause notice, but without a challenge to that, how can I come in? I can be doing study here, na? You think, seriously think of, madam, that show cause notice is bogus. I thought once that I'll finish it up, but I can't. I should not, because that challenge is not there. But tell Mr. Borua, okay?
Please.
Etu 2টা বজাতে আছিল, 2:30 কেনেকৈ? Mr. Chomoria, this was at 2 p.m. Nobody was here in 2 p.m. So,
My lord, we were before 1:55.
You were here overtime. Yes, what is this additional
Lordship, we have
affidavit?
paid the amount.
Filed an additional affidavit, my lord. Lordship will kindly have a look. Annex page 335. This is given by the bank. That particular check was deposited in this account number. The check was returned to the account holder due to the cutting of the so-and-so, so-and-so.
Where do I get it?
Page 335. There were cutting, reason for return, my lord will see. Down below, second last point. Cutting or amendment in the date or amount is not allowed. Date was, my lord, cut and a new date was incorporated. And check leaf was delivered to the representative of so-and-so on 26/6, and proof of that, my lord will find next page, page 36, 336.
Where?
Page 336.
Okay, when
1,
was
2,
the
3.
check issued?
Check issue date was December 20. I'll just give the specific date, man.
29/12/2023.
I'm sorry.
12/2023.
29/12/2023.
To the first party by check bearing number so and so. Dated 29, State Bank of India. Second party with respect to payment of consideration against so and so, so and so, so and so, so and so.
Page 336, my lord, if see.
336.
336. This is the statement given by the bank of the check referred and return registered.
Okay, let us see the
Serial
check number
number
045007.
Yes.
So where is 0453-007?
The serial number 3, my lord.
1,
2, 3. 045007.
045007,
7 lakhs.
Return to Bikram Singh Lawkar. Cutting on amendment in the so-and-so not allowed. So when was, this was done on 35. 35, 2024. Okay.
Cutting on the
Okay, okay.
date in so and so.
Now come to page 335.
Yes,
Now let us see. This is your bank,
this is
chief
the bank.
manager. Okay. The copy of the check, the copy of our bank's check return register is attached with, presented on 35/2024.
Yes.
Now show me, this was presented within 3 months. This manager,
that
I'm getting him now.
No. I'll
Getting the manager here now.
Before,
No,
taking
Mr. Chaudhary, Mr. Das, 3 months time is there for a check. How can you present a check after that?
Lordship, that thing I have already explained in my affidavit.
Okay, let's see that explanation.
Yes, my lord. Para 4, my lord. May I read, my lord? That after the offering of the check, prior to that, my lord, I have in para 3, I have stated how the discussion started, from when. I have given an email also to that effect to show that the discussion started when, with that respondent number 4. That after the offering of check, the petitioner in the first occasion placed it before the branch manager, SBI Gauhati Airport.
Okay, now this has happened.
Yes.
This has happened within 3 months. Where is your communication to the party number, the opposite party, that this check is not presentable because of these defects?
No, Lordship will kindly 4 and 5, my lord. 4 and 5, Lordship will. Look, what happened, my lord? I'm making the submission, my lord. What happened, my lord?
This is something which you knew, but it is not reflected in the petition. 1.
No, that's true.
1. 2, show me. Now this is an afterthought. Show me that as on that day, because you got this 7 lakhs in terms of giving over something, that this check was not encashable, not presentable. It was not executable. Where is your stand?
So, para 4 and 5, my lord.
No, you just tell me. I don't want to read. You just tell me.
Oh, I'm extremely sorry, my lord. On the first occasion, when the check was given to me, it is the petitioner's, my lord, he presented the check.
When?
To the bank.
When?
My lord, date was not given.
How will we believe it?
Lordship will kindly have a look, my lord.
I'm having a look only.
Yes. It was presented to the bank. Then the bank said the seal of the trust, since it was a trust.
When was it?
No.
Okay, let us see it like this. 29/12/2023 is the date of the check.
I'll just explain. It was, my lord, it was not presented for clearing. The petitioner, my lord, he gave the check to the bank manager saw it, and bank manager communicated to the petitioner.
When? That is the date I want.
My lord, date not mentioned.
Then how can it be? You can't have a vague thing. You go before the trial court to prove it.
No.
There is a reason why I'm asking you this. I'll tell you. But first you give me your clarification.
Yes, I'm giving the clarification. The first thing that happened, I showed it to the bank manager. Bank manager said that the seal of the trust is not there in the check. So this will not be cleared. So I took back the check from the bank manager and gave it to the representative of the institute who was here. I have given the name of that person also, my lord. Now he took the check and he sent for necessary change in the check, my lord. Then they incorporate the seal, but in the date of the check, they have did the correction by hand. And
where is that check copy?
Check copy is lying with them, my lord.
Wait.
My lord, because bank manager second time.
Now.
One second, my lord. 1 second. Second time, I did not deposit the check, my lord. The representative of this particular organization, Rashmi Ranjan Nayak.
Where?
Para 5.
Because this check was returned to you.
No.
Yes. Come to the check return register.
No, my lord.
You come to the check
kindly
return
come
register.
335. Kindly come 335. Check leaf was delivered to the representative of Vidya Bharati Educational Trust. And they are saying from the...
This is Chief Manager, State Bank of India.
Yes, my lord.
Got it.
Airport, Gauhati Airport branch.
Oh, any standing counsel? How can he return a check to a non-customer? He can't.
No.
Where is your
because
endorsement?
Check was presented by,
Array, Mr. Das, you are a rich man. You have enough transactions in the bank. Can your check be presented by me in your account and taken back by me? It cannot be. That is one of the very underlying principles of banking. You cannot. No bank. I'll have this man now put to task.
suppose,
Now tell
one
me.
second, one second.
Forget this.
Suppose I
Forget
want
this.
to pay, suppose I want to pay Mr. Chamaria,
You.
no, I want to pay Mr. Chamaria 10,000 rupees.
Hmm.
I have signed a check, and can I not deposit the check to the bank
You can.
in his account?
You can. But
That is what
check,
had happened.
No, but that check leaf, if something is there, will not be returned to you. It will be returned to Mr. Chamaria only. It cannot be returned to you. Once that property comes into my account, anybody can go and deposit any money in my account. There is no problem. I can't stop them. I don't know. If today, tomorrow you go to my account, give them a check of 5 lakhs in name of UK Nair. The bank will take
Because
it.
check
No,
was
no.
in my name.
Oh, bank will take
Check
it.
was,
Bank will receive it. Give that endorsement, check received. Then the bank will check it, send it for clearing. Or it will do whatever it is to be done.
today online, nowadays
Every-
online
online.
clearing is there.
But the check, after it has come into my account, your check maybe, it has come into my
Whoever
account.
deposits it.
I'm sorry.
I'm
Those
just-
please.
I'm
Those
just
please.
explaining what.
Those please again show that you are having something.
No, my lord, lordship will kindly have a look. My lord, because when I deposit a check, it comes with a counterfoil. I incorporate the.
Where is that counterfoil?
My lord, it was never deposited by me. On the second time, it was
Okay.
deposited by Rasmi Ranjan Patnaik, my lord.
Okay.
Let them show from the records that they have
Forget
paid
it.
7
Forget it.
lakhs.
Forget it. Now you tell me. This check had a validity. 29/12/2023. 29/12. That is a plea nowhere taken. Now you can't, we will not permit you. That is not a plea taken in the.
Right, my lord, lordship will keep aside everything.
One thing.
Keep
one
aside
thing,
everything.
one
Let
thing.
them show from the records that they.
Let them, you first clear. One thing you tell me. 29/12/23 is the date of the check.
Yes, my lord.
Validity is 3 months.
Yes.
It finishes say 27 or 28/3/24. Now come to your agreement.
Second day of March 2024.
2024. So this check was with you from 29/12/23.
No.
29/12/23. That is the date
No,
of the
my
check.
lord.
29/12/23 is the date of the check.
Date, my lord.
Mr. Das, I'll have to have some material
I understand, my lord.
higher in standard of proof than this. You
Lord,
read paragraph
my
1
lord,
now.
what I'm feeling is that I am not able to convey to your lordships. I am failing to convey to your lordships what have. My lord, the discussion with this organization started in the month of, that also I have annexed, in the month of July 20.
Oh, Mr. Das, I'm not concerned with this. I'm concerned with para 1. You come to page 36.
Page 36 is kind of the part of the agreement, my lord.
Hmm?
The check part clearly mentioned in page.
We know, Mr. Somaria. We want something, we'll get to you. Para 1, read that once more.
In pursuance to the aforesaid agreement and in consideration of sum of rupees 7 lakhs, which the second party has made to the first party by check bearing number so and so, State Bank of India, Gunupur branch, Orissa.
Well,
The second party,
with respect to the payment of
the
consideration.
second party with respect to payment of consideration against the handing over of approval license for running the aircraft maintenance engineering college, the first party hereby admits and acknowledges the sufficiency of consideration price, my lord.
So, as on 2/3, you have not said anything. Why did you accept this? You have not said anything about the check.
As on 22nd of March.
2nd of March. And
Lordship,
yours
this
is
was a-
presenting
Lordship,
of
this
the-
was a business dealing. This was a business dealing, my lord. Then why? Look, before entering into agreement, why they have given me check on 29/12,
That is a part
2023?
of that agreement.
No, that's what the, no, that,
And
it
now
was
come
a,
to
it's
para
a
two.
business process.
Oh, come to para 2 of
Of?
that thing, that same page
Para 2.
of that
Yes,
one
second
para one.
party, second party on the strength of this deed may create, establish so and so College of Aeronautical Engineering with new accountable manager to be nominated by the first party, and first party shall have no claim whatsoever on the said business with effect from complete execution, and henceforth the first party is no way liable and responsible for the affairs in connection with the College of Aeronautical Engineering AME branch.
So you are giving up everything. You have given up that part, aeronautical engineering, to the second party. Everything.
Only the approval license.
No, you have now read
Ultimately,
further.
same thing,
No,
you
no,
know.
read
Ultimately,
further. Read
yes.
further.
Shall hand over all the powers and privileges on aircraft maintenance engineering of College of Engineering to the second party.
Hmm.
Yes,
Now come to para 5.
that on behalf of both the parties, the new accountable manager of GIETU shall apply to the DGCA for.
So
change
you
of
are
location.
agreeable to the change of
This is
location also?
original view conceived by your lordships, my lord. I am
No,
not, I am
no,
not disputing these
No, no,
things.
no, no. I'm
My
not saying that.
arguments are above this.
You come down. Let us get the basic facts right.
Yes, my lord, fine.
Shall support. Then come down to 9.
9. The said party having full right to hand over the said approval granted by DGCA hereby handed over to the second party and will not at any time hereafter revoke, annul, make void the aforesaid handing over hereby given by the said second party, do or execute or knowingly and willingly suffer an act, deed or thing whereby the said second party may be prevented from having and receiving the said approval and any part thereof, and to and for his own use and benefit by means of whatever whereof the said second party shall be injured in the said business.
Now, why do you know that the nomination of the second party as the accountable manager was required? Because even prior to this, you had appointed the second party here, that Panda, as a accountable manager.
Prior to that, I have cancelled also and they have accepted also.
Prior to execution of the agreement.
Prior to the impugn order.
No, no.
2-3.
Prior to the execution of the agreement.
Yes.
You come to page.
No, prior
32.
to the agreement, Panda was there.
No, you come to page 32.
1 second. Yes.
Here, Bikram Singh Lawkar had appointed one Panda.
Chandra Dhwaj Panda.
Panda. Now, what happened is, now you come to page 34.
Yes.
Last paragraph. Whereas,
first party is the accountable manager, College of Aeronautical Engineering, dealing with job of imparting and providing education under the name and style so and so.
So now, what has happened? That appointment of Dhwaj or Panda, Chandra Dhwaj Panda, had not been approved by the DGCA till that time. That is why you continue to project yourself as the accountable manager. Now you come further. Come to page 42. This is an agreement. Para 3. That the second party on the said deed so and so with a new accountable manager, so and the first party shall have no claim whatsoever on the said business with effect from complete execution, and henceforth the first party is nowhere liable so and so. So this is what this court finds from the materials on record. Now I have disclosed my mind. Now you make your submissions.
Fine, my lord. This
you are not challenging the agreements.
No, my lord. I am against the impugn order. Basically, I am on 2 points, my lord.
Yes, what is that?
Firstly, when the accountable manager was discontinued by the petitioner and it was approved by you, as per the agreement itself, it is the accountable manager who is required to initiate the process of change of location. I'll just take your lordships to that relevant portion.
We have seen it.
It is the accountable manager. No one else can do. If that be so, how the impugn order came without the processing by the accountable manager? But because on the date of impugn order, prior to that, the petitioner became the accountable manager. So anything done by Dr. Panda is without any authority. And if that is without any authority, then the other impugn orders wherein the certificate has been renewed, those are, my lord, vitiated. That is my first submission. And that my approval as accountable manager, your lordship will find page 61.
Yes. DGCS approval.
24/7/2025.
DGCS approval.
Yes.
Hmm.
24/7/2025. Page 61. So as on 24/7/2025, the petitioner was the accountable manager. So if the petitioner was the accountable manager on 24/7/2025, the impugn orders were passed on 13/8/2025. Why this high-handed action
Where
by
is
the
the impugn
department?
order? Where is the impugn order?
Impugn order 86, 87, and 88. Down below the date. Same person, Valte. And page 91, the appointment of accountable manager. How did you do it? Without my forwarding? Because I am the competent person who can appoint an accountable manager. Page 91, 7/8/2025. If on 24/7/2025, I became the accountable manager by following what process you have on 7/8.
What is the process for appointment of a accountable?
Process is same, my lord.
No, where is that?
Likewise, in the earlier
No, where is
occasion,
the
I
rule?
recommended someone's
Where
name.
is the rule? Where is the procedure?
No definite procedure is
Then,
There is a procedure, my lord. We have enclosed in our affidavit of opposition.
okay, where is that?
fine.
There is a rule contain, my lord,
Exact procedure?
yes, my lord.
It starts from 111, 114. Then where is that?
My lord, this is the procedure manual in my affidavit of opposition.
Where is that exact
my lord.
position? That
201, my lord.
Huh?
201,
201.
airworthiness procedure manual. And lordship, this two things which is relevant here, contained in page 208.
208,
Change of
your
yeah.
original affidavit or the running page of this code?
No, my lord, original affidavit, my lord.
208?
My lord. One contained about that change of the basic approval. And page 209 contain 5.5 about the change of accountable manager.
208.
Yes, my lord. Full listening.
No, there is a mistake
My
here.
lord, extremely sorry, my lord. I think pagination.
You find that out first. You find it out.
Yes, my lord. May I place, my lord?
Just show me that.
Pagination will be open. And here is a case, my lord, restoration. It is not a case of new appointment, my lord. There are two segments. One is change of location, another is the change of accountable manager. My lord,
We'll come back to it. Yes, Mr. Das.
No specific procedure has been provided. I have also gone through this here, my lord. No specific procedure has been provided that who will appoint the accountable manager, how it will be appointed. But
Then
if
next-
we go by the process which has been followed or which is
The
agreeable,
proprietor or the organization has to do it.
yes,
Got it.
that is the conventionally, my lord, it is the
Accepted. Next.
yes, proprietor who has to do it. So now my humble submission is that if the DGCA, how did they pass this impugn order dated 7/8/2025 appointing Mr. Panda as accountable manager when on 24/7/2025?
Okay, you have said that, we have noted that. Next.
Yes, so in that view,
That is bad in law.
the bad in law
Then
and all
next.
the consequential orders,
Bill.
because
That's
for
the only argument.
for 13/8/2025 also,
Hmm.
for the impugn orders dated 13/8/2025 also, the process has to be done by the accountable manager if you go by the
The
agreement.
change of location.
Change of location.
Hmm.
So if the accountable manager's appointment is not valid, how those orders can be valid? my lord?
Okay.
That is one submission.
Hmm.
Second submission is with regard to, my lord, consideration of 7 lakhs rupees. Section 25 of the contract Act says if there is no consideration, that agreement is void. So it is my categorical case here before your lordships, which I am trying to convey to your lordships, my lord. I have filed the additional affidavit also to demonstrate that 7 lakhs rupees never deposited in my account, my lord. That 7 lakhs rupees never deposited in my account. I have given a specific communication given by the bank that 7 lakhs rupees never deposited. There may be many things in the communication, my lord, that who is the owner of the check. Ultimately, my lord, if the check is deposited, the amount will come to my account, that particular account. So let them show that they have deposited 7 lakhs rupees in my account pursuant to that agreement in against that particular check, my lord.
Okay. Anything more?
So that is precisely my argument, my lord. I will go by this page 335, bank
is that?
certificate and the
335 is what?
of the additional affidavit.
Oh, additional affidavit.
Yes.
Okay, we'll look at it.
And one more thing, my lord. I'll just 7/8/2025 was a Thursday. Then, my lord, Saturday, Sunday, 8/9. Then week starts from 11/8/2025. Monday. 13/8 are the impugn orders. So this undue haste, is alarming, my lord.
Okay.
I'll urge upon a point.
So is it your case that because of non-deposit of the money, the agreement is void? Or your case that the agreement as sought to be interpreted by the respondents is not correct?
No, my case is that since the consideration did not fulfill,
That is your case. You are
the
sticking to that.
agreement is not executable.
You are sticking to that the consideration not having been transferred. Occasion, section 25 would come in.
Yes.
And the agreement is null and void.
Yes.
Right? It is not your case that the agreement as being sought to be projected by the respondents is wrong. If the consideration had flowed to you, the institution would have moved away from your hand.
No, there, no. Lordship will kindly appreciate. There I have the second argument regarding the accountable manager. You are relying on the same agreement.
Very, we got it. Now tell me whether the agreement is valid for non-consideration.
Both count.
Both count.
Both count, my lord.
Both count.
Because you cannot say that one portion of the agreement will act upon and other will violate.
What is the thing of handing over the property and facilitating change of location?
They can never be the owner of the property, my lord. The College of Aeronautical
So,
Science.
Mr. Duck, you also agree that the agreement as such.
Is only for.
No, is
change of the-
disputed. It can be interpreted in both ways. You interpret it that it was only the license, a license has been given of the license.
No, there is no dispute. I'll just explain, my
Hmm.
lord. Lordship, I'll make myself clear. My lord, the agreement, I'll just take your lordship to the agreement.
No, you tell me.
No, the agreement is with regard to the approval license. That they will run that particular course, the respondents.
In Orissa.
No,
also.
no, I'll just explain. That facts also I have got.
You mean to say
Initially,
that the second part will come in only the accountable manager doing that.
Exactly.
Okay, done. Agree.
So, my lord, they, after the agreement, they initially conduct classes here.
No,
Three-
that is there on.
3%.
Okay, let us hear, Mr.
So,
Nothing more, this much only?
so this much only.
Yes, but Mr.
If something in addition requires, my lord, I
The reply is always there for you.
Yes.
My lord, on last occasion, we have been given a direction to place the record, place the detail of it about the payment part, my lord, 7 lakhs.
7 lakhs only.
Yes, 7
You
lakhs.
might have paid him crores. We are not
No, 7
concerned.
lakhs, only 7 lakhs.
What is your chance?
My lord, here is a case that he has placed the half-hearted story. Huh? Nadi.
That is why you are here to complete the hurt.
Yes.
You complete the hurt.
My lord, only thing is that, my lord, initially lordship cleared that the check was dishonored. Second time overwriting, that was dishonored. Thereafter, my lord, kindly see, he made a communication to us to pay the amount in different mood, page 7, my lord. If harm he has shown, and out of which, my lord, the all payment were duly made as per his requisition, all the documents are there.
Check amounting to so was initially issued on 29 in favor. However, since the check could not be encashed, the date of check was subsequently revised and check was reissued on 4/4. Now it comes within your Mr. Das, now it comes within your 35/24. That period.
That is
The
what-
bank declined to
Convey.
honor. Thereafter, upon the advice of so and so, based on background said by him through WhatsApp, the agreed consideration was remitted through different bank accounts as detailed below. Okay. 22/7, 3 lakhs. 23/7, 2 lakhs. 2 lakhs. Thus, the interest runs fully paid.
Page 11, my lord, we are confirmed.
Therefore, the aforesaid payments were made strictly in accordance with the account details through WhatsApp communication. Neither so and so has any business relation. So and so. Instruction for his web. Where is this instructions? Okay, that we'll see. These documents clearly establish the entire consideration duly paid and received through bank accounts nominated by him. Whatsoever remains, whatsoever.
Now, lordship, page 11, my lord. We have confirmed, and he never disputed. We have remitted fee notice of payment of rupees 10 lakhs. Please make a document mentioning detail in 100 stamp paper and have number 2, Mr. Rasmi. This is the second part of communication. He never opposed. And bank confirmation, page 14, my lord, about 7 lakhs. As per his requisition, the all parties received the amount. There was transmitted and bank has now confirmed that transaction, my lord. It is not a case, my lord, that 7 lakhs was not paid, my lord. At first time, my lord, on last occasion.
So in addition to that, some other amount was also.
Yes, my lord, that page 13 more than crore, my lord. He has shown numbers of dreams, my lord. Even, my lord, he has badly beaten to our, my lord, employee.
Okay, that is something different. You go and file a FIR for it.
We have filed a FIR, my
Okay,
lord.
fine. That will take care of that.
That's why, my lord, because.
Okay, now what do you say? The first point gone.
Yes, my lord.
What
I'm
do you
coming to
say
the
about
first
the
point.
second
What is the
point?
meaning of, my lord, he has raised the issue of a void contract, my lord. He's basically that because 7 lakhs was not paid, therefore, in terms of section 25 of the contract, it is no lordship. Void contract meaning thereby, my lord, if suppose there is no consideration, then it's a void contract. Suppose a contract was made, no, suppose consideration figure, like there is an exemption given in section 25, that in case of my lord, gift and etc., consideration not required. That also treated as a, my lord, a valid contract. Now, in case of my lord, suppose a contract has not been performed, suppose there is 7 lakhs rupees we ought to pay and it has not been paid. Then it comes to my lord section 37, breach of contract. Then he has to enforce the contract to approach before the civil court and my lord claim the remedies, my lord.
Contracted.
My lord, kindly see, my lord. Just look, lordship, page section 25 for a moment. What is the exact language incorporated therein? Page 20, section 25.
Okay. Then
And 37,
is
my
it?
lord, section 37. In case of breach, my lord, party can approach to the, my lord, proper.
Okay.
So therefore, my lord, now let us again, my lord, a void contract even, my lord, does not require any, my lord, declaration from the civil court. It is a law. Voidable contract required. Even it is not a case of voidable, it is not a case of misrepresentation of fact or my lord, fraud or my lord.
No, what do you say about that? We have understood. What do you say about the
At
second
the
part?
at best, my lord, suppose at the best, it is a figure incorporated therein. Therefore, consideration is there. If I would fail to suppose do so, my lord, then section 37 come into play, my lord. The law is very much clear, contract is very much clear, my lord. Now, will my lord 226, my lord, can enforce to a 37, my lord? I think it is not possible, my lord.
Okay.
Now, second aspect, lordship.
You have also not, you have also suppressed this fact
No, my lord.
in your written statement, in your
What, my lord?
reply.
Which part, my lord?
That 7 lakhs.
My
was
lord,
paid.
at no point of time, any utterance, my lord. A single word, never, my lord. On last occasion, first time it has been raised, my lord.
There is no pleading. You mean to say there is no
Absolutely
pleading
not,
in
my
the
lord.
petition, so you did not reply.
Can you take it for a moment? My lord, 7 lakhs is a figure, my
Now
lord.
let us see your written statement to that effect.
Objection, my lord.
Objections.
My lord, we have noted everything about their counterpart, whatever they have alleged.
No, with regard to payment, nothing has been said.
Because, my lord, it is never raised, my lord. Why, my lord, this issue has been raised by a transaction has been made, my lord, crores in rupees, my lord. He is fighting for 7 lakhs, my lord. Not looks like good, my lord. My lord, thing is that, my lord, what happened? He has, my lord, he is a.
Mr. Das,
I'm so sorry. I'm so
you
My
have
lord,
your
kindly see, my
opportunity.
lord, it is his duty, my lord. He is now before the court of equity. my
Okay,
lord.
forget it. Now this we have understood. Now the second part.
Second point is that, my lord, he is saying about, my lord, new appointment. It is not a case of new appointment, my lord. Lordship, just look, their own pleadings. My lord, paragraph 17 of the writ petition, page 20. He himself said once again word he is used. He never said it's a fresh appointment. Because earlier I was there, he supposed by virtue of some wrong information approached before the authority entered his name. Afterward, we opposed, clarification was made. Then, my lord, the position was restored. It is a case of restoration. Page 17, my lord, page 20, paragraph 17, that the petitioner begged to state that recently it has come to the knowledge of the petitioner that the respondent number 3 has accepted Chandan Dwaj Panda once again as the accountable manager. Word is very much clear. Now, lordship, kindly see their affidavit. Respondent number 3, what language they have incorporated. Respondent number 3 affidavit, my lord. What is the language which they have used?
Yes.
My lord, respondent number 3 file affidavit, paragraph 13. They also use the same language, my lord. It is a case of reappointment. My lord, it is not a case of fresh appointment. What my learned friend is.
So was the subsequent engagement of acceptance of the petitioner as accountable manager cancelled?
My lord, reason is that, my lord, he unilaterally made the approach.
Oh.
And authority was not in, my lord.
Okay, where is that cancellation?
About their part, my lord. My lord, it is a clear letter that has been clearly
show me
given.
that cancellation,
By,
Mr.
my lord, in their affidavit, they have clearly mentioned everything.
There is an order?
Yes, my lord.
There is an order
Of cancellation.
Accepting his
him
as the accountable manager?
Quite right.
Now, that order is superseded by, you say, a restoration of the earlier order.
Yes.
Show me the order by which it was restored.
My lord, writ petition, my lord.
Yes.
Page there P and 4. restoration part that contained, my lord, in page 80. I'm giving a list.
The earlier order is at page 48.
Yes.
And the subsequent order you will find at page 91.
91, my lord.
Huh.
91 with the collected.
Now, Mr.
So,
Chamoria,
my lord.
you say this is restoration.
My lord.
Where is that restoration?
My lord, restoration is a language they
The
himself.
language we don't
My lord,
understand.
my lord,
You tell me that this is, if you say it is restoration, where is the restoration?
My lord,
Because this page 48 order
my
was
lord,
already
my lord,
superseded.
exact language not used, but let us
Then
see,
if
my
it
lord,
is not used,
my lord,
use-
antecedent we have to see that
Oh, no,
Panda
we
was
haven't
there.
anticipated.
Lordship, kindly see, Panda was there.
Where have they said in their affidavit?
Yes, ma'am.
That this
yes,
was-
Yes, ma'am, quite right.
Where? Come on.
My lord, the affidavit filed by the respondent number 3 was going. There. And 4. Now, Lordship, kindly see the detailed
Para?
explanation they have advanced in paragraph. Paragraph 13, page 10.
One.
13, 14.
Where is this order? They have said that. Where is that order?
About cancellation.
Huh? Revocation.
My lord, revocation.
Where is that revocation order?
My lord,
He has said many things.
my lord, kindly see.
Para 13 is records. Show me the revocation order. That
My
will-
lord, yes. Lordship, kindly see, it's a,
Oh, am I looking at it very harshly?
no, my lord. My lordship is
You
now,
show me this.
now-
Yes, Madam Pukon, where is the revocation order?
but suppose lordship kindly take it for a moment, the revocation, suppose it is a, my lord, it's implied that it's a restoration has been
Implication
done
will not do,
automatically, my
Mr.
lord, and it,
I will only bound them by their statement in the affidavit.
my lord, if suppose there is a procedural part incorporated that prior to a cancellation first done, then restoration would be done.
No, it said revocation.
My,
It revoked and
okay,
was reappointed.
Lordship, lordship take.
Yes, Ms. Pukon. You will not know about it. Ms. Pukon will know. Yes, Ms. Pukon. What do you say in para 13? Where is the material to support that? Why have you not annexed? You say it's from records. Get the records by tomorrow. Tomorrow, 2 p.m. But the petitioners at some further length, Ms. Pukon shall justify the contentions made in para 13 of the appointment of the petitioner as accountable manager being revoked and the respondent number
Respondent number 6.
6 being reappointed as accountable manager. The note sheets, including the discussions preceding the issuance of orders revoking the appointment of petitioner as accountable manager and reappointing the respondent number 5
Respondent number 6.
6 as accountable manager be placed on record. Kali no lage? Budhbare ko idea. On Wednesday, 2 p.m.
But lordship, only one submission, my lord.
We'll see here the submission.
My lord, revocation, my lord, kindly see, lordship has now suppose seeking a clarification or revocation.
If I have to revoke, I'll have to pass an order revoking. I can't do it in air.
It's a, my lord, if suppose the appointment was done.
Next. It'll by slip.
Deeply obliged.
You're still in deep sea. This
I
is
understand.
something which has come out, giving you slight breathing space.
Lord, I'm just fascinated by their instruction. My lord.
lordship,
7 lakhs divided into
my
3
lord-
parts, check numbers were
My
different.
lord, he's
Fine,
a
my
big
lord.
player,
Mister,
my lord.
don't
He's a
go
big
into
player.
that. You will be in trouble.
I am a big player.
You're
I am a big
It's
player. my lord.
clear, my lord, that he has received the amount. And my
These
lord,
dialogues, you go out, both of you, and make it there. Don't make it
I
in
have
my
never
court.
made any submission.
You don't make
Someone's
such
big player.
dialogues in my court.
Sorry,
The retort will be very heavy.
sorry, my
Please
lord.
don't do that.
Extremely sorry.
If you have anything personal, go out,
My lord,
break your heads. I have nothing to say. But not inside my court.
my lord.
I can't break your head,
No.
but my orders will
No,
be
my lord.
breaking
No,
something.
extremely sorry, my lord.
Please don't repeat
Yes,
this.
my lord.
Much obliged.
But you be careful, Mr. Das.
Yes, my lord.
Yeah.
Item 30, Lord. Regarding subsidiary allowance area. Police authority was
Uh-huh.
already forwarded, my lord, at page number 39.
Lordship, my instruction just received.
Yes. What is this?
Lordship, this is.
Huh? Ask your director to come online.
No.
We'll talk to him now. Mr. Counsel, you come to page 30.
Yes, Lordship.
Huh? What have you written here? That this issue is beyond.
Yes, Lordship.
Huh? Then a order is void ab initio. Where is the further requirement? Now, why have you come up with this plea?
No, Lordship,
Take this court for a ride.
No, Lordship, this was issued way back in November, Lordship.
Whoever it is. Whoever it is. This is not done. In 21, you say that this issue is beyond my
Yes, Lordship.
thing. Where is the question of that order being required to be further justified? Not required. Immediately within 1 week, release is substance.
Yes.
Mr. D. Upamanyu, Learned Standing Counsel, Higher Education Department on instructions have submitted that the speaking order passed in respect of the petitioner on
Page 30.
5/10/2021. Having reinstated the petitioner by revocation, by withdrawing the order of so and so, the period of suspension not having been regularized, comma, the petitioner is not entitled to receive salaries for the said period. Also, a perusal of the earlier order dated 5/10/2021 would reveal that the revocation of the order of suspension of the petitioner was so made by reckoning that the misconduct alleged against the petitioner was so committed by her in an organization beyond the jurisdiction of the Directorate of Higher Education. Also, the said order dated 5/10/2021 was essayed by the petitioner before this court by way of instituting WPC number 5648/2022. The said writ petition was disposed of by this court by order dated 2011-2023, directing the Director of Higher Education Assam to examine the claims of the petitioner for release of 25% area salary for the period of her suspension, along with leave encashment and group insurance scheme. So it is seen that no order has been passed thereafter by the respondent authorities regularizing the said period of suspension of the petitioner. This court having directed the examination of the this court in the said order dated 2011-2023 has also noted that no disciplinary proceeding was instituted against the petitioner in the matter. The petitioner superannuated from her services on
My lord, 31/12/2021.
31/12/2021. More than 5 years, more than 4 years have lapsed since 21, na?
21.
More than 4 years have lapsed since the date the petitioner has superannuated from her services. Accordingly, it would not be permissible today to institute any disciplinary proceedings in the matter against the petitioner. Accordingly, the Director Higher Education is directed to process the matter and to finalize the pension, and to release the area salary receivable by the petitioner for the period she was under suspension. For such orders be placed on record on the next date of listing. Registry to list this matter again on 5/8/2023. Don't. Nothing is there. Why create a molehill?
Yes.
Why create a mountain out of a molehill? Just to cross the date. Yes.
Reply, please.
Yes. How much will you give?
7,000.
How much are you getting?
Total 40,000.
Huh?
14,000.
14.
Is there.
No, you are getting 14,000. You are giving the mother
40.
40. Oh, 10,000. Mother 10,000. Agreed? We dispose of. Those.
Lord, if it is divided equal share, then
Still have expenses, medical. You're not looking after her. 10,000. You tell me, I'm closing this matter.
My lord,
Or it will be more than that. I'll direct for a provisional payment, 10,000, and give her liberty to go before the court to claim maintenance from you. 10,000. 10,000. Oh, so the heard Miss A. Das, Learned Counsel for the petitioner. Also heard Mr. B. Islam, Learned Counsel. No. Also heard Mr. Pegu, G. Pegu, Learned Government Advocate, appearing for the respondent number 1 and 3. Also heard Mr. M. Sharma, Learned Counsel, appearing on behalf of Mr. B. Sharma, Learned Standing Counsel, Accountant General, bracket A&E, Assam. Also, the petitioner in the present petitioner by instituting the present writ petition has prayed for a direction upon the respondent authorities for also authorizing to her a proportionate share in the family pension being received by the respondent number 4 in pursuance to the death of the son of the petitioner in harness. Full stop. The learned counsel, the petitioner herein is the mother of late Thaneshwar Burman, who while working Krishnakanta Burman, who while working as a lower primary teacher
Krishnakanta Burman
at Puroni Bongaigaon Usso Bunyadi Vidyalaya had died in harness on account of natural causes. In pursuance to the death of the son of the petitioner, the family pension as required now to be authorized was so authorized to his wife, Shanti Priya Chaudhary, that is the respondent number 4. It is the projection of the petitioner that that she was totally dependent upon her son for totally dependent on her son, and after his death, she was not, no provision was made for her necessities by the respondent number 4, which had led to the institution of the present petition. Mr. B. Islam, Learned Counsel, appearing for the respondent number 4, on instructions have submitted that the respondent number 4 is willing to provide an amount of rupees 10,000 every month to the petitioner for her maintenance. Ms. A. Das, Learned Counsel for the petitioner, has also accepted the said proposal made by the Learned Counsel for the respondent number 4. However, she submits that the said amount is to be so paid to the petitioner with effect from 1/4/2026. Or you want it from 1 January? Compromise. 1/4/2026. Which is also agreed to by Mr. B. Islam. In view of the above, the respondent number 4, give me a bank account number.
Present.
You give a bank account, your bank account number. Yeah, we'll record it.
I will give it to
Just give it to her. If you don't get it today, give it to her by tomorrow. Then only I'll sign the order.
Yes, yes.
The respondent number 4 shall, on the family pension being credited to her account, transfer an amount of rupees 10,000 to the account of to the following account of the petitioner. Account number 2, name, account number, branch, IFSC code. With effect from with effect from July, within a period receipt of family pension. On deposit of the amount, family pension amount, within 7 days thereof. So, the areas receivable by the areas of the amount required now to be paid to the petitioner by the respondent number 4 with effect from 1/4/2016 shall be paid in installments starting from July 2017 and be paid in in 5 installments of 6,000 each. So 6,000, 5 months, and from next month, 10,000. Areas from
Well, petitioner prays for equal proportionate amount, my lord.
proportionate amount.
My lord.
You want me to determine that?
No, sir. I am only.
You give the number.
On the place.
In this account, full stop. In the event the petitioner fails to deposit the amount, respondent number 4 fails to deposit the amount as agreed to be so paid to the petitioner, for 2 consecutive months, the petitioner shall approach the jurisdictional treasury officer, who, on a receipt of such representation from the petitioner, shall forthwith stop further payment of family pension to the petitioner, to the respondent number 4.
Yes.
You have to look after your mother also, no? And she is not very greedy.
Absolutely correct.
She said 10,000, 10,000. Fine, very good.
Absolutely right. It is required.
And if she does not give, file an application, they'll stop you.
Reply.
If you give your bank account, huh? Otherwise I can't sign this out. Okay. Yes.
Sorry, my lord, actually, I tried to contact my client.
Need not contact, but this will not be maintainable.
My lord, lordship will get some time because I have to inform him, my lord, about if lordship will close this matter. If liberty, we have to approach the cat. So I have to inform him for that reason, my lord, immediately after vacation, maybe.
Okay.
I'll write letter.
On the prayer of Mr. S. Dr. Learned Counsel for the petitioner, registered to list this matter again on 16/7/2026 for further hearing. Yes.
My lord, my lord, the order was not reachable, but I have somehow collect, my lord.
No, you were supposed to file an affidavit.
Yes, my lord. Friday, my lord, only I have received from the district, my lord.
Then that day you said that you would bring it on record.
Yes, my lord. That was actually misplaced from the commissionerate office, my lord. The second page is, my lord. And it was informed, my lord, on 9th March.
How many petitioners are there?
Only one. Two, my lord. Two.
But here we have about Pranab Dole.
Yes.
What about the other one?
Namaste.
You have any order? Okay, you give him a copy.
My lord.
Where only Pranab Dole, where is the other one?
At anyhow, my lord, we will file affidavit, lordship, immediately.
Registrate, Mr. Dr. Samit has placed on record date. Record a communication dated 9/3/2015 issued to the petition number 1, by which he was informed that his contractual engagement as Gram Rozgar Sahayak will not be renewed from the month of March 2015. However, similar communication issued to the respondent number 2, petition number 2 has not been brought on record. Mr. Dr. submits that he would file an affidavit, invariably file an affidavit on or before 27/2026. In bringing on record, they said orders, bringing on record the orders issued towards discontinuation of the engagement of the petitioners as Gram Rozgar Sahayak. Registered to list this matter by on 24/7 or 27/7/2026 for further hearing.
I'll file it. Always.
Both respondents, my lord, already retired, my lord, some time maybe will not file impleading petition, my lord, contempt petition.
On the prayer of the Learned Counsel for the parties, registered to contempt, registered to list this matter again after the ensuing summer vacations.
In the last occasion, Lordship, counsel for respondent number 1, I mean that some amount was not received by them. Mr. Srishti is to apprise this court, Lordship, today. That day, Srishti was not present, Lordship.
There is an instruction here.
Lordship, last occasion, Lordship, last order. Are not complied with, Lordship. That is page 14. Lordship.
Yes, yes, Lord.
Yes, that amount has been paid to
Yes,
you.
yes. On last occasion also I have
Yes, this order is there.
in a month of May.
Yes, Your Lordship, the letter has been received by the university authorities. However,
Amount?
the amount has not been received, Your Lordship. I have confirmed today itself, Your Lordship.
In the account, it is shown that it was
Is hereby accorded for drawal of pension contribution to so and so in respect of so and so.
Yeah. In the
Now,
second phase,
whether that amount has been deposited.
the account number has been given. Lordship.
Oh, account number has been given, that
Yes.
whether the amount has gone into the account. Mr. Chisti submits
Yes.
that. And order dated 11/5/2026 has already been passed, already been issued. According pass for drawal of pension contribution at the rate of 18% payable to the Assam University Silchar in respect of the petition service of the petitioner. Service rendered by the petitioner as subject teacher in JS High Secondary School, Behar Bozar, Kachar, during the period 11/5/94 to 14/7/1997. He submits that he would apprise this court as to whether the amount involved has actually been deposited in the account of the Assam University. So he prays that the matter be taken up immediately after the ensuing vacations. Prayer accepted. Registry to list this matter again after the ensuing summer vacations on 23/7/2026. Mr. Chisti, to
Yes.
apprise this
I'll
court
get.
about the deposit of the amount involved in the account of the Assam University. Ms. Upadhyay shall also complete her instructions in this connection. Yeah.
In 47, I have the instruction that Lordships, the director, the initial order was issued in the year 19/12/2018. And thereafter, in the 2021 Lordship, the Assam State Level Recruitment Commission that has came into force. Now now the director has written to the commissioner for giving an approval that there is a 2 posts still vacant. Lordship, the present director has written to the commissioner to give approval. After that approval, Lordship, she will conduct that Lordship, that interview immediately. So for that, Lordship, I need
Mr. SMT Sisti, Learned Counsel appearing for the respondent, has submitted that processing of the matter is at an advanced stage and the selection as directed by this court would for the post of against the post of LDA in Gograpar Girls High School would be conducted shortly. Accordingly, he prays that the matter be taken up on 30/7/2026 so as to facilitate him to apprise this court of the developments taking place in the matter. Prayer accepted. Registry to list this matter again on 30/7/2026. Mr.
No, I have told them that you have to
Lordship, she is
comply
a
because
I know
widow.
that
Lordship, she is a widow and she has been serving since 1995. That's the thing.
No more comments. We'll see next day. Mr. Chisti has made his stand clear.
Yes.
There was some delay. We want to get that thing done. So let us say she will do it. You just have some patience. Yes, item.
I'm blessed.
That's it. My lord, 2021, my lord, contempt matter. And then, my lord, detailed order is there on 30th April, my lord, if lordship may kindly.
Amount 20,000 deposited.
Moment.
Yes, what is that,
Non-public
Mr.
knowledge.
Chisti? You file a review,
Yes.
then you say that there is an appeal, but where is that appeal filed?
here, Lordship, Mr. D. Musai, she was appearing on, she was handling the matter. Lordship, I couldn't go through it.
Where is Ms. Musari?
My lord, respondent number 6 earlier approached before the filed and read appeal. My lord. That was dismissed.
Dismissed, sir.
Thereafter, they have preferred and review application. That was also dismissed.
Dismissed with cost.
Yes, my lord, dismissed.
Yes. Get Miss Hazurika, Miss Musari. Tomorrow would be difficult, Thursday. A prayer is made on behalf of Ms. D. Musari for accommodation in the matter, learned counsel appearing for the respondents for an accommodation in the matter today on account of personal inconvenience. Prayer accepted, registry to list this matter again on Thursday. Why slip koidiba? Huh? Slip koidiba.
49,
Yes, where is the order?
Your order, no lordship, may kindly give us time till last week of July, lordships,
What?
on 27th of July.
Why?
I had a conversation with the secretary, lordship.
Mr. Chistik, learned counsel for the respondents has submitted that the processing in the matter is at an advanced stage and the compliance order would be placed on before this court on the next date of listing.
Yes.
Accordingly, registry to list this matter again on 28/7/2026. Same order in item number 51. No?
Yes, both are together.
Now he's giving the compliance order, wait for certain. Otherwise, Mr. Abedin is very large.
Yes. No, my lord, already more than about 3 years, then why creep for another month? And when there is a chance of getting the order, deeply obliged. ma'am.
It is 2001 finally got relief on in 2025, your lordship. Till then order-
Yes, what is this?
Well, I need some time, my lord.
We're all retiring, lordship, very shortly.
Yes, why this order was not complied with till now? Have you filed an appeal against this?
Not yet, my lord.
Huh?
Not yet.
Not yet means order is of 2/12, 6 months down the lane.
Okay.
Yes, why, what is the instruction?
I have not received any.
Then we'll have to ask them to come and explain.
Next week, any day, my lord.
Huh?
Oh, after vacation, my lord. Immediately
After
after,
vacation,
well,
okay.
immediately after vacation,
Okay.
I'll.
Mr. P.K. Bora submits that the compliance order in the matter shall be placed before this court on the next date of compliance order towards after implementation of the directions passed by this court would be placed before this court on the next date of listing. Accordingly, registry to list this matter again on 3/8/2025 for 2026 for further consent.
Sometime in July, your lordship, because of
Compliance order.
Lordship.
Why get it?
Lordship,
He's
lordship.
giving a compliance order.
Lordship.
No appeal, Mr. Enakali. Mr. P.K. Bora, learned counsel for the respondents have submitted that no appeal and or a review has been filed against the order, violation of which is called for in the is alleged in the present present contempt petition. Accordingly, he submits that he be granted time till 3/8/2026 to place on record the compliance report after implementing the directions passed a wide order dated so and so in so and so. Registry to list this matter again on 3/8/2026. If you have not filed a review, if you have not filed an appeal, you will have to comply. That's all. Simple. None appears for the petitioner on call. For the ends of justice, registry to list, Mr. S. Das, learned standing counsel, Higher Education Department is present. For the ends of justice, registry to list this matter again after the ensuing summer vacation on a date to be fixed by it.
Please, your lordship. My lord, there are two, my lord, one is for impediment, my lord. Here, my lord, the petitioner has challenged the transfer orders on the ground that he has been transferred and the fact.
One thing I don't understand. Your retirement is in 27. Now, you are saying that this is not only an order of transfer, this is an order of transfer on promotion.
Yes, sir.
Now you are not joining against that promotional post. Now, how will that benefit accrue to you?
My lord, the petitioner has submitted one representation that has. not
Forget
been
the
considered.
representation now without that
There is
order being
vacant-
implemented.
Vacant post is available.
That is for the government to decide.
Yes.
You are from electrical.
But they have not passed.
You are
any-
from electrical. You have got
From
nothing to do with
from
instrumentation.
Instrumentation engineering.
You're not an instrument, you're an electrical engineer.
Instrumentation engineering, my lord.
Your appointment is as an instrument
Yes.
engineer. Show me that.
That is in the writ petition, my lord.
Okay, where is it? If you come to page 24, electrical engineer. In 2005, you joined as electrical engineer.
But in the instrumentation engineer.
Where is
engineering
that, madam?
He has developed, my lord.
Oh,
Yes,
he's
the
developing
bottom
is
thing,
something
yes,
else,
my
but
lord.
where is he? Where is he? Show me that.
He's in as instrumentation engineering.
No, come to page 31.
Say
Your
okay.
posting is at electrical engineering.
My lord, now, my lord, he has been promoted.
Oh, where, madam? Show me.
My lord. My lord, it is also reflected
Oh, forget the thing. Show me that, madam, where it is.
28, 29.
You come to your order of transfer, page 37, recommendation. It is electrical engineering.
Electrical engineering, Dipankar Chandra.
Now you want to implead whom?
Complete, my lord, the person, my lord, in favor of whom an order has been passed during the, my lord, status quo, my lord, operation of the status quo order. In this petition, my lord, there was a status quo order on 29th of May, my lord.
You want to bring in Satyajit Bhuya.
Yes, my lord.
Satyajit Bhuya is instrumentation engineer.
We
It's
are
a different
against-
post altogether.
We are not against his promotion. We are, my lord,
Oh, madam, you may have been given some duties, but that duties does not fall in your department. No order is called for, madam. We are sorry, we are rejecting this. He is totally on a different footing altogether. Satyajit Bhuya is under mechanical engineering department, instrumentation. You may have been given some data and you go and join, otherwise you will be loser.
he is ready to forego, my lord.
Ready to forgo?
Yes, my lord.
Then let him to ready to forgo, let him stay here.
Yes, my lord, he wants to say.
You will record it that you want to stay here. Yes, Mr. Das.
My lord,
You give an application in writing by tomorrow.
my lord.
Give an application that you want to forgo. You
Yes.
want to stay in Gauhati. But you will not get instrumentation. You will be in electrical.
Same.
Same. When shall I put it? Friday?
Yes.
Huh? As agreed to by the Learned Council for the parties, registered to list this matter again on Friday. Huh? Ms. S.B. Chaudhary submits that the petitioner desires to forego his promotion as professor and would like to continue as associate professor in Assam Engineering College. She submits that application in this connection shall be preferred by the petitioner by tomorrow. The Director of Higher Education Assam shall thereafter decide on the said application and pass appropriate orders thereon within a period of further period of during time by Wednesday by within a period of 15 days thereafter. Registered to list this matter again on 14/7/2026.
Does correspondent number 5.
Miss M. Miss M. Das, but Miss M. Das, Learned Council for the respondent number 5 is present. You give that application, let them take a call. And you keep her in the engineering department concerned.
My lord.
That is electrical.
My lord.
We are not coming. Yes, why have you not taken steps?
Step.
Huh?
Step with you, sir. We have taken, my lord.
Notice has been issued. No steps with regard to sped post, no steps have been taken. Seen the office note dated 19/6/2026, which reveals that The petitioner is yet to take steps for service of notice upon the respondent number 6 by way of speed post. It is also revealed that the steps taken for service of notice upon the respondent number 6 by way of usual court process, the service report has not been received. So petitioner will submits that he would take steps for service of notice upon the respondent number 6 by raised by speed post within 2 working days from today. Registry to list this matter.
Already taken is 19 lordship.
Taken.
19.
Show me. Why? 5-6 notice. You want the case listed daily. You're taking it on 19th.
Usual process.
At this stage, notice step line work like question. However, the learned counsel for the petitioner had submitted that his steps for service of notice upon the respondent number 6 by way of speed post was taken on 19/6/26. The petition, the registry to verify the said aspect of the matter and proceed accordingly. Registry to list this matter again after 6 weeks, 4 weeks from today. Yes, something.
There is a short term remain, my lord, then
Huh?
getting dissolution of committee. So, date will kindly fix.
After vacation, you don't take steps, you take steps, you come back, we'll see. Send the office note dated 19/6/2026, which reveals that notice was issued upon respondent number 5 by speed post on 5/6/2026. However, the same is not complete. Registry to await completion of service of notice upon respondent number 5 for further 3 more weeks. Yes.
Your lordship, and for respondent, service was not completed.
Your fourth, respondent number 3.
Yes,
Mr.
S. Kotsu,
S.
on
Kotsu
behalf of RM Das.
appears on behalf of the learned, on behalf of Mr. R.M. Das learned. Standing Council, Dima Hassau Autonomous Council has entered appearance on behalf of the respondent number 3. Accordingly, service upon the respondents are complete. Registry to list this matter for admission hearing after the ensuing summer vacations.
In this case, I am not pressing pair number 4, my lord. Because my lord, I have retired from my service. So my lord, I am not disputing seniority.
Now tell me, when there are clear-cut directions from this court not to barring promotion from group 3 to teacher, how could you have been promoted? Your very promotion is that. We'll say that you will be considered as LDA, no recovery.
In the meantime, my lord, I have retired from service. My lord, my pension has been finalized.
Finalized where?
My lord, as teacher, my lord.
Get that on record. Mr. Ayat Soikia, learning counsel for the petitioner, submits that in the meanwhile, your petitioner, he has superannuated, the petitioner has superannuated from his services and the pension and pensionary benefits of the petitioner has been so fixed by reckoning him to be a graduate teacher. So, Mr. Saikia submits that he would file an additional affidavit in this connection.
I'm respondent number 4, Lordship.
What is there now? He's retired. Why are you pursuing with this?
Lordship, I have objection, Lordship.
What objection?
Because he illegally, Lordship, last time he barred me to cancel me from this petition, Lordship. Initially, he is get me harassment, Lordship.
So now it is not a service dispute, it is harassment dispute.
Personal harassment.
We'll see. Registry to list this matter again on.
He illegally take this benefit, Lordship, assistant teacher. That is very interesting question, Lordship. He was upgraded 1990. He was upgraded 1996, but he take this graduate skill from 1993, Lordship.
How did you come in?
Minor.
How did you? How was your appointment? Initial appointment?
My appointment is 1994, Lordship.
Selection.
How was it? Selection?
Lordship, I am was
Yeah, Hindi.
Lordship.
Then?
I was initially I was a Hindi teacher. My service was regularized on 2000.
When was your service regularized? Okay, you get your facts clear. On 29/7/2026. You file your affidavit. So that would be a factor we'll have to consider.
In the meantime, my service was confirmed also. After confirmation, I have retired. Only because of that interim order passing the earlier criminal litigation, my lord, this diversion order was passed. However, my lord, in the division bench, my lord, turnout.
It's because of the voting as condition. I don't know anywhere. Yes.
In the division bench, when I put that order on challenge, interim order.
We'll see. We'll see. We'll see. We'll see. No.
Obligation.
Lordship, I have to be with senior counsel in.
Today will not be possible. We'll have it some other day.
Lordship.
Heard Ms. Mbora, learned counsel for the petitioner. Also heard Mr. S. Das, learned standing counsel, higher education department. As agreed to by the learned counsel for the parties, registry to list this matter again on 29/7/2026 for admission. No, for as a top of the list, no? For admission, I will get position method.
31, I have some difficulties, Lordship. 31.
31 you have, no, 29.
Okay.
Thank you.